I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what the day is. But it's exactly what you make it. So please don't go wasting. And I'll do the same, even if it's raining. How could I complain? And my feels got me feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. Of what a good day is. What a good day is. And that's exactly what the day is.
All right, we are in the building. Y'all know what to do. It is a beautiful day. I see y'all saying, thank God it's Friday. We in the building. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. Let's go. We should be good up in here. Oh my goodness. Look at how crispy and clean on the screen. Woo. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE Beats, ClassEBeats.com. Patreon.com/ClassEBeats, by the way. Link is in the description as well as in the pinned comment in the chat. We got a great show for y'all today. A lot to get into. We got Wendy Williams. We got Soldier Boy. We've got, Fannie Willis. This is going to be an action-packed show. As you know, we've been covering the TAY trial as well. So we're going to get into day 7, 8, and 9 is starting today. So we're going to actually hear some testimony from Mark Saldivar's mother. All right. So we're going to hear from her. We're going to hear what the jury instructions are going to be. And then we should be able to get to closing arguments today. So before we get into it, I got to shout out the people, though. Shout out to everyone that's in here. We got the whole gang in the building. Y'all know my awesome, amazing Amy is in the building. Shout out to Amy. Thank you for everything that you do. I appreciate you. We got Les Cleaver in here, Michi, Libby22, SC Girl, A-Fits, Axel Wheel, Valencia, Trisha, Kara Hampton is back in here as always. We got Rhonda Hall in the building. Shout out to Rhonda. She dropped a 10 bomb over on Cash App yesterday. Appreciate you, Rhonda. Tay Toom is up in here, and I see a bunch of y'all in the building too. I appreciate every single one of you that are here. If you could, do me a favor. It's free to do, and it really does help the channel out if y'all do this. Please take less than a second and like the video. Not only is it free, as I mentioned, not only does it help the channel continue to grow, but it lets the algorithm know that you guys are enjoying the show, and it shares the video, the live stream, the channel out with more people. So thank you to everyone who does that every single show. So many of y'all show up and are liking the video instantly. We've already got over 100+ likes, so y'all know I'm gonna be begging for likes throughout the show. So I appreciate every single one of y'all that have done that so far. Also, I will be reading super chats as we go throughout the show as well. And I see a couple of y'all already sent some super chats in here too. So let me read these super chats real quick, and then we will get right into the content. All right. My guy, Les Cleaver up in here with the 5 bomb. He says, thank God it's Friday. May your day and weekend be blessed and full of love. Please be safe and have fun. Thank you, Les Cleaver. I hope you have a great weekend as well. We got a lot going on this weekend, so no slowing down, as y'all know. We got Kara Hampton in here as well. She dropped a 2-bomb, says, good morning and happy Friday. Good morning to y'all. Let me know in the chat what y'all have going on this weekend. What are y'all getting into? I know a lot of you are on spring break. There's a lot of people on spring break here. So some folks are on vacation, which is nice. Hopefully the weather's been holding up for y'all, but let me know what y'all are getting into this weekend. And thank you to Amy again for reminding y'all to like the video. All right, we should be good. I think we can go ahead and get into our first topic. Again, I'm going to be asking y'all throughout the show. Please, 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 please like the video. It takes 2 seconds. All right. So let's go ahead and get into it. Y'all know one of my favorite topics on this channel, and I'm sure as Fanny knows too, is the Fannie Willis Smoke Show. All right. So we've got another edition of Fannie Willis is going to get some smoke up in here. So we're going to talk about what's going on. There was a new bill that was recently passed that may mean some issues for Fannie Willis. We're going to look into it here. I've got an article for you guys to explain exactly what the bill is and actually how it could affect not only Fannie Willis, but possibly some of the members or some of the defendants in the YSL trial and people who have been in certain situations in the past. Let's check it out by 11 Alive.
Well, back here at home, a proposed law that would secure compensation for those wrongfully convicted and later exonerated in Georgia took another step forward. State Representatives Katie Dempsey and Scott Holcomb, they held a news conference this morning alongside 3 exonerees who spent decades behind bars. They said that House Bill 533 could be a pathway bringing Georgia to a new place. They also say that this bill would create a system that is fair, removes politics from the process, and compensates people for the time they lost.
So the answer can't be from the state, and I am a former prosecutor, we're sorry we got it wrong. We're sorry that you lost your freedom. Now figure it out.
Yeah, and didn't we see this with Yak Gotti, a guy who sat in prison, who sat in Rice Street Jail for 2+ years, was found not guilty. And they're like, huh, sorry about that, bud. I guess you were here for no reason. Not only that, but he got held longer because of something he did while he was in jail. I mean, this system's so broken, and we need bills like this to discourage certain people from abusing their power. It's sad.
The only
It's
thing
sad.
that we can do is to compensate them. Those monies will never truly compensate them, but they can at least give them a start on a new life.
Yeah.
We do know that Georgia is only one of 11 states who do not pay restitution to those wrongfully convicted.
Isn't that crazy, y'all? Georgia doesn't pay restitution. Insane. And as a taxpayer here, I'd be happy to pay for this. If someone's kept in jail and they were wrongfully accused or they were in there for a crime that they didn't commit, I, as a taxpayer, would be happy to make sure these people get taken care of, because that changes your whole life. And we've seen, just based off of what somebody says or what somebody thinks happened, there have been people that have been in prison for decades and decades and decades, and finally to find out that, oh, well, maybe we got it wrong. Disgusting. What does Atlanta News First say about this bill? Georgia bill would compensate the wrongfully convicted, allow Trump to recover cost of election case. Oh, so it sounds like the president, 45, 47 is going to benefit. A reviewed attempt to fix Georgia's insufficient system for compensating people wrongfully convicted of crimes almost died. What happened? A revived attempt to fix Georgia's insufficient system for compensating people wrongfully convicted of crimes almost died because of the General Assembly's adjourning this past Friday. Then the measure got tacked onto a bill that can compensate President Trump and more than a dozen co-defendants for attorney's fees after they were indicted for attempting to overturn his 2020 election loss in Georgia. The bill combined Senate 2244 won final approval before the last day of Georgia's legislative session. If Georgia Governor Brian Kemp signs the bill, it would let the criminal defendants recoup attorney's fees and related costs in cases where a prosecutor gets disqualified and the case is dismissed. It would also establish a state law requiring an administrative law judge to award $75,000 per year of incarceration to people who have been found wrongfully convicted if they prove they are innocent of the crime or any lesser offense. This is going to change a lot here. This is going to change a lot here in Georgia if this goes through. And it's going to change a lot of the way the system is run here as well. We're going to keep reading, but it'll be interesting to see how it affects the DA's office and how it affects their process of indictments as well. Georgia is one of 12 states without a law compensating people wrongfully convicted of crimes, according to an analysis by the Georgia Innocence Project. Instead, a lawmaker must sponsor a measure to compensate people and get legislative approval, a process plagued by politics that often leaves people without money, including 5 who tried this year. The original half of the bill has a different backstory, though. Trump and 18 co-defendants were indicted in Fulton County in August of 2023. Fulton County District Attorney Fani Willis was disqualified from the case by a state appeals court based on a romantic relationship she had with special prosecutor Nathan Wade, whom Willis hired to lead the case and overpaid him. This is what the state led the state Senator Brandon Beach, an Alpharetta Republican, to bring forward a measure. He was recently named Treasurer of the United States by Trump after years of support of the president, and argued that the indictment was politically motivated, which we've seen because Fani Willis and the mayor of Atlanta went to the White House right before they launched this attack on the president. Punitive politics. The measure passed the Senate 35-18 with all Republicans voting yes. The 3 highest ranking Democrats crossed over to vote yes. Oh, okay. That's surprising. House Minority Leader Harold Jones II of Augusta, House Democratic Caucus Chair Senator Elaine Parrott of Atlanta, and House Democratic Whip Kim Jackson of Stone Mountain. But many Democrats were not on board. I understand some people have allegiance to the president and some people voted for him, and that's their right. But do not force my constituents to pay his legal fees. Well, were y'all saying that when we were paying Nathan Wade? You're awfully quiet then. But anyway, Atlanta Democratic State Representative Shay Roberts on Wednesday called the bill a disgusting display of punitive politics. The bill passed 103-61 in the House. It puts legislators and voters in a moral straitjacket, Roberts said. If you want to support justice for the wrongfully convicted, you also have to support protecting powerful politicians from accountability. What? That's not leadership. That's hostage taking. Who is she talking to? I can't tell who she's talking about here. A longstanding push. The bill's passage came the day after Republican Senate Minority Whip Randy Robertson held a 4-hour committee meeting at 6 a.m. on a measure to compensate 5 people whose convictions were overturned after years of incarceration. Happens all the time, man. By then, it was too late for the proposal to get a vote. Robertson, a former sheriff's deputy, has been the lead opponent against past measures to compensate people and establish a law to let legal experts make that decision instead of legislators. People seeking compensation this year have had convictions overturned based on findings such as DNA evidence, legal and police errors, and the discovery of new evidence indicating they did not commit the crime they were incarcerated for. But Robertson said people wrongfully convicted aren't necessarily innocent because convictions may be overturned due to technical errors. I mean, that's a fair point. He also has doubts about whether some of the people seeking compensation this year were innocent. Again, if you're going to argue against the system, then we just need to overhaul the entire system. You can't say, oh, this one part's okay and this one part's not okay. We got to be consistent here. Still, he said the current method is flawed, and he decided to support this year's bill to take the compensation process out of the legislators' hands. I think that was a good decision. Republicans sponsor State Senate Representative Katie Dempsey of Rome said the bill will let the wrongfully convicted have a true chance that is not a retrial for legislators. Democratic Representative Scott Holcomb, who has championed the wrongful compensation bill for years, begged Democrats in both chambers to vote for a measure he called one of the few incredibly consequential bills he has worked on. There isn't a person alive who would trade the money that these individuals are receiving for what happened to them in terms of being locked up in our state's prisons for usually decades of our lives for something they didn't do, he said on Friday. Absolutely well said, and I 1000% agree. So good to see this come through. Obviously, there's going to be some things that need to be ironed out, but I think they made the right choice in moving this bill forward. So we'll have to wait and see what happens. We'll have to see how this affects the DA's office and Fani Willis too, because if this is the case, I can't imagine that they would move the same way that they move, because they're going to end up costing the state of Georgia and Fulton County specifically more money. If you're paying $75,000 a year for however long you had to spend in prison if you were wrongfully convicted. So it'll be interesting to see how that goes moving forward. Let me know what y'all think about this in the comments and in the chat. Wow. Shout out to the gang in here too. I see all 300 plus of y'all in here. Oh, I lost the chat for some reason. Hold on a second. We got to get the chat back. Why did I lose my live chat? Here we go. Let me see what y'all are saying. Didn't you know she married Rico? Shout out to Les. How is it ever okay to incarcerate or convict someone falsely? It's not. They should have compensated. Yep, they should be compensated. I agree. It is said that 4% of those incarcerated are actually innocent. This suggests that approximately 2,000 individuals in Georgia prisons may be serving time for crimes they did not commit. Shout out to Amy for the statistics there. And even if it's one person, that person needs to be paid. So, hey, just figure out the parameters, make sure you get that right, and then we'll do what we got to do. But to be honest, I would rather pay somebody who seems to be wrongfully convicted and needs help getting another chance than to pay Nathan Wade 4 times what he's owed. I mean, that's why I think this statement by Miss Roberts was interesting, because if you're going to talk about that and you're going to worry about someone getting paid who doesn't deserve to get paid, I mean, we need to go to the root of the problem. River Run ATV Park in Jacksonville, Texas. Oh, okay, y'all are talking about someone else. Fani messed it all up too many times, and I'm still such as to why she got reelected. Ignorance, really. People don't know what's going on, or they don't care, or it's because she's a black female Democrat. And if you don't vote for her, then you're going to get your black card snatched. And there's a lot of blacks folks here in Fulton County. So I don't know. Wow, you're right, though. One person is too many. Paying Nathan for tapping Fani is diabolical. Oh, no, I think Nathan Wade now deserved to get paid for that. Because, I mean, if this is what he had to deal with, then yeah, somebody needs to pay him. All right, I gotta chill. All right, we're gonna get into our next topic here in a second. Let me see if I can find this picture. Oh man, y'all didn't hear me say that though. I'm gonna have to clip that out. Nathan, man, send us a sign if you're in trouble and you need some help. Just let us know. We'll get you taken care of. I thought I had a picture of Keefe D here, but I'm struggling to find it, y'all. So we're going to go ahead. Y'all know what I like to do. Put Judge Whitaker up there, and we'll get into this topic here in a second. No more silk dresses on taxpayers. No one went to vote. I mean, it was surprising. I think Fani Willis won by 63%, and Courtney Kramer got 38%, if I remember right. Let me see. Fani Willis re-election results. So I believe it was yeah, I had the numbers flipped. She won 68%. Courtney Kramer got 31%, 31.9%. Again, that's impressive, in my opinion. She got a third of the votes in Fulton County. We had just over 500, just over 500,000 people that came out and voted. Let me see one more thing. I want to see how many voters, how many registered voters we have here. We have, and I should know this number. No one went to vote. It is Fun Friday, so get your last in. I need to send you a picture of me having my Coke with Paige. Oh, you got to meet Judge Whitaker. Shout out to Judge Whitaker. Oh, wow. A lot of folks voted for her. That's how it goes in Houston. People talk trash about the governor Hot Wheels, but he still keeps getting elected. So I don't know why. Greg Abbott's amazing. I don't know why. Why wouldn't you like? I don't know. Let's see. So voters in Georgia, 7 million, but I want to see Fulton County. How do we find it? Amy's going to find it before me. I'm trying to out Amy. I should be able to find this simply. How many voters in Fulton County? Hold on a second. I'm going to find it for y'all and then we'll move on to the next subject. So it looks like there are about 900,000 and 500,000 voted. So yes, who said that? Monterisa was right. Nearly half of the folks didn't come out to vote. If y'all want to see the demographics, there's 45% are white, 35% are black, and then you've got a little bit mixture of the rest. 55% are female, 43% are male, and the majority of them, 26%, are from the ages of 50 to 64. So that would make sense. That's amazing that there's that many people registered to vote in. So many of them stayed home. Yeah, y'all aren't rocking with Greg Abbott. Greg Abbott's amazing. I hope he runs for president in 4 years. I'll vote for him. She's not as bad as Tiffany. YSL Whitaker. Put some respect on her name. Shout out to YSL Whitaker. Anybody who's from Texas, how do y'all feel about Greg Abbott? Let me know. All right. I've done enough talking. Let's go ahead and get back into it. So y'all know on this channel, we've been covering what's been going on with Keefe D. Not only is he being held and awaiting trial for the, the you know what of Tupac, but he actually was involved in some other things that went on inside the jail. Most recently, he got into a fight and now he's in trouble and he had to have a hearing about this. We're going to see what went down and we're actually going to hear from him and his attorney as to what happened and why he got into this fight in the first place. Here we go.
My name's Carl Arnold. I represent Mr. Davis. Mr. Davis is not guilty of the crimes charged. Let's start with the easy one first.
Oh, this is really low. I'll turn it up for y'all.
Mutual combat. Mutual combat is defined. Mutual combat is defined as this: previous concert and agreement. A person fights with another person. Highlight the word previous. Please highlight the word previous. The reason why I want you to highlight that is the state didn't meet its burden. What evidence? None. Of a previous agreement that these two were going to get down and fight each other. There's absolutely no evidence. We heard from the officer that listened to all of his phone calls. all of his phone calls since 2003. No evidence of that. We asked the officer, the supposed ex-detective that is assigned to investigations, the first person that testified, what was said under these doors. He doesn't know. No evidence. No evidence of previous concert and agreement. What we have is this gentleman, Mr. Hamilton, unlawfully hitting my client. As Mr. Brooks said, that's one thing all three of us agree on. Mr. Hamilton willfully and unlawfully struck and battered my client, okay? This is why my client's not guilty of battery. He did not unlawfully strike back. They want to say the fight started, when my client's foot turned to him, etc. That's not when the fight started. And I was thinking about it.
And we're going to watch the video of the fight shortly.
The evidence that we have is Mr. Hamilton was well aware that my client was coming to see me. He started to form the intent right then and there that he was going to get out and come get my client.
So he was threatened.
Then he gets into the room. We'll go ahead and play the video. Gets into the room, does that. He's facing, like I said, towards the mirror, towards the sink. Goes and takes a look. This is when he knows.
That's not Keefe D.
Right then and there that my client is getting ready to enter into that room.
This is the guy who Keefe D allegedly attacked.
Right there. He knows that the guy that just went to his attorney visit, the guy, for whatever reason, he doesn't like and he wants to attack, is about to come into that room. What does he do after?
This is the alleged victim here.
Not my words, ladies and gentlemen. It's not. It's this officer's words. That officer's words are evidence that you can consider. I didn't say it, he said it. He positioned himself behind the pole. You know why that officer said that? Because that officer is in agreement with the three of us. Mr. Hamilton's plan from day one, when he went into that room, when he positioned himself there, was for this to happen. And that's the attack of my client.
There he goes. The camera moved away, and I'll show you guys a better view of this video. But basically, you can see the alleged victim is standing here. Keefe D starts to walk in this area, and he turns towards him. Now, again, it's going to be kind of like we saw on the ASAP Rocky trial. It's going to be a timing situation. Like, what was the timing like? Did Keefe D lunge at him first? Did the guy say something aggressively? That's tough.
The most important exhibit in this whole entire trial is Exhibit 13. The state put it up there for you. And they want to show you the profile of the video where you see his hand balled up. But Exhibit 13 shows both hands down. This thing happened instantaneously, okay? It was super quick. Both hands down show an indication that I'm not an aggressor. There's a cop right behind me. I don't know what you're gonna do, but I'm looking at you because you just said what's up to me. Both hands are down. And this guy starts approaching him, and he's approaching him not like 1, 2, 3, 4 seconds. This is instantaneous. What is one to do? What one is to do is protect themselves. You have that right. You have that right by law.
He might have said your
Okay?
mama.
And so we go to the battery instruction. number 11, and it says, it's only battery if it's willful and unlawful. It's lawful if my client is standing his ground and choosing to protect himself.
Is that what the law says when you're incarcerated? I don't know that.
As you will see in the instructions in regards to self-defense, if my client was the initial aggressor, if my client was the one that said, "What's up?" first, if my client was the one that ran away from the officer and tried to attack Mr. Hamilton, he wouldn't be afforded this defense of self-defense.
And it's alleged that the alleged victim in this case, the other inmate, was left alone by the guards before this went down. So again, somebody mentioned in the comments, was this a setup? Hard to say.
But that's not what happened. What happened is, again, my client turned, "What's up? What's up?" back to you. And then the fight ensued.
I'm never, ever going to jail.
Quote from Franklin D. Roosevelt in regards to World War II. And it says, when you see a rattlesnake poised to strike, you don't wait until he has struck to crush him. Thankfully, that's what the U.S. did in
Well,
World War II on both sides of the ocean. And that's what my client chose to do. And it's his God-given right to sit there and not be attacked by another individual.
well, here's the thing about jail. We want to talk about God-given rights. Some of them get taken away if you go to jail. Let's be real. So again, I don't know, and I'm not familiar with the law when it comes to self-defense of as an incarcerated person, but they not like us. Let's be real, right? You lose certain rights when you're in jail. And it's just a tough situation to be in. Tough, man.
We turn to instruction 15. A bare fear of bodily injury is not sufficient to justify the use of force. This was not a bare fear. At this juncture, this individual is reared up. His hands are in a position where he can take a swing at my client. My client's hands are still down here, but he knows that this rattlesnake is poised and ready to attack him. And that's when it went into action. Again, these are split seconds. Instruction number 16. Again, it says that the right of self-defense is generally available is not to an original aggressor or to a person who has sought the quarrel with the design to force an issue. Again, let's look at the evidence. What is the evidence? Nobody knew that Mr. Hamilton was in the room. That's the evidence that we had from the officer. The officer said, we didn't know that he was in the room. They were there for standing for a minute. The officer said there was no discussion about seeing Mr. Hamilton in the room. That's the evidence. Again, what evidence does the state have that my client knew that he was in that room?
Right,
What
and so what we
evidence
have
has the
ultimately
state given
is
us
that
to
there
show
is no
that my
evidence.
client intended
None.
to hit this guy? They haven't given any. And it's their burden to do that.
Mm-hmm. What do y'all think from what you've seen in the video so far?
Go to instruction 18.
Look at this judge. She looked like she about to fall asleep.
If evidence
she got her mouth
of
open and everything.
Defense is present. And that's what we're seeing. This is your evidence right here, that self-defense is present. This man is lunging after him. We know that he's the original aggressor. We know he was waiting for Mr. Davis to round that corner, because it was his plan all along to come in and attack my client. And so, my client, there's evidence that he needs to protect himself. Now the burden shifts. The burden absolutely shifts because we presented that evidence through videotape. It's up to the state now to give us evidence beyond a reasonable doubt that self-defense is not afforded to my client. They don't have that evidence because they can't sit here and tell you what were the thoughts that were going through my client's mind. What they're trying to do is saying, look, we have all these things he said about the fight, okay? But when did he say those things about the fight? After the fight. You all have either been in a fight or have heard when a person's in a fight, they're going to give the best version of what happened in regards to them. They're not going to say, yeah, man, he got me, beat the living tar out of me. That's just not what's going to be said. What's going to be said is, yeah, I got him, yeah. You know, we listen to
So he bragged about it? Come on, man.
Mr. Davis did. And he goes, oh, he only got one punch on me. I looked at the tapes. You guys don't have a chance to look at the tapes. That's not true. So that's not even good evidence. Out of my own client's mouth, they're going to use that as their good evidence? Fail. That doesn't work. It doesn't work. The state cannot prove beyond a reasonable doubt that my client did not act in self-defense. My client, pursuant to self-defense, can stand there, can take this guy approaching him and react. That's what you're allowed to do by law.
Okay, that's what he said.
Next, hasn't been argued yet, but it will be argued that instructions were given to Mr. Davis and to Mr. Hamilton to stop the fight. Decease, quit, stop the fight. Okay? And since they were given those instructions and they continued to fight, well, that takes away his self-defense. No, it doesn't work that way. Okay? Here's the thing. Self-defense goes to the person that believes they're in imminent danger. That's what the jury instructions say, okay?
Shoot, in jail, that's all the time.
He was in imminent danger when he made that turn, saw that guy in the corner that said, "What's up?" and he's coming at him. Right then, my client knew he was in imminent danger. It's not what the officer does and says, "Oh, stop the fight. You guys break it up." No. All that is number one, the officer not interfering and stopping the fight. But number two, my client is still getting beat up on. At this time, you know, Mr. Hamilton has him turned on his back. Mr. Hamilton has the advantage. So, again, what's going through my client's mind? The only evidence you have of that is the video. My feeling is you guys are really understanding the case, really understanding the law. And so I only have a couple of more comments. The bottom line is this, that you have two kids at school fighting. Someone swung on the other kid first. The teacher's yelling, "Stop, stop." It's the same situation that we have in this case. There has to be someone that threw the punch first or initiated the aggression. And that's what we have from Mr. Hamilton. He's the initial aggressor. My client felt he was in harm, and and my client had the right to protect himself. Go to the last line. This is mutual combat. Mutual combat, again, is a previous agreement. If you remember the scene from this movie,
Is that Rocky?
these guys came to the gym,
Is that Rocky and
took off
Creed?
their clothes, put on their boxing gloves, and said, let's do it. Let's do it outside of the audience of everybody else. Let's have this fight. There's no evidence whatsoever that the state has laid that shows that. That's mutual combat. We don't have any evidence of mutual combat in this case. We have evidence of self-defense, and we have no evidence that the state can provide to us that shows that he's not entitled to self-defense. So
let me know what y'all think about that. Based on what you've seen, based on what you've heard about this story, do you think Keefe D was the aggressor, or was this a setup? Was he attacked? I want to know what y'all think about this in the comments in the chat, because in the next video, we're going to tell you what the verdict is and what the judge decided. Let me know what y'all think. And I see a lot of y'all commenting on this in the chat too. Yes, this is Keefe D. It's a shame that it's a shame that we are actually watching a court case of two incarcerated people fighting. This is funny and sad all at the same time. A jail fight is on trial. Yeah. Tay said, I think he murdered Tupac. Dang. So we're just jumping. Tay said, forget this little fight. Go ahead and lock his ass up. Dang. All right, I see y'all. Well, if that's how you feel, we might as well go ahead and get into this next part, because the judge came back with a verdict, and I'm not going to lie. Based on what we saw in this video, and we're going to replay the video here, I'm surprised the judge came back with this verdict when it comes to Keefe D and this fight he got into in jail. But we're going to see what the judge decided. Y'all let me know what you think about this in the comments in the chat.
It is video our 8 News Now investigators showed you first. Now a jury is deliberating whether or not the man accused of orchestrating the murder of Tupac Shakur acted in self-defense in this jail fight.
All right, hold on. We got to rewind this back because I want to play the video. I would play it in slow motion, but I'm just going to pause it. So you see a guard with Keefe D. You see the alleged victim walking towards him.
Our 8 News Now investigators.
Man, I don't know, y'all. It looks like Keefe D was minding his own business.
It is video our 8 News Now investigators showed you first. Now a jury is deliberating whether or not the man accused of orchestrating the murder.
One more time.
It is video our 8 News Now investigators showed you first. Now a jury is deliberating whether or not the man accused of orchestrating the murder of Tupac Shakur acted in self-defense in this jail fight.
Dang, man.
Dwayne Keefe D. Davis on trial for that fight that took place last December.
So it's breaking news here at 5. The jury has reached a verdict. 8 News Now, the only TV station in the courtroom, and investigator David Charnes is live from the Regional Justice Center. And boy, David, that was fast.
Super fast, Denise. This all started at 9 this morning. They deliberated for 90 minutes, finding Dwayne Keefe D. Davis guilty for the video you just...
Dang! They found him guilty. It's all about the timing. It looks like Keefe D raises his hands up first. Again, we watched the video a couple times. Y'all let me know if they got it right on this one. Tough, man.
For 90 minutes, finding Dwayne Keefe D. Davis guilty for the video you just saw for that jail fight. Remember, this is the same man that prosecutors say orchestrated the 1996 murder of Tupac Shakur, but you wouldn't have known that sitting in court today. That name Tupac was not mentioned once. Let's show you more of that video from that day in December. Prosecutors say it shows Davis and that other inmate tackling each other inside the Clark County
I don't know about this one, y'all.
Tussle lasting about 30 seconds before officers pulled them apart. Now, in court today, prosecutors played jail calls where Davis says that he got his expletive, he told a family member. He also said, quote, "I let him know you can't expletive with me, little man." Now you can fill in what expletives were used there. Davis's attorney said that his client was attacked. Now, trying to sway the jury that he acted in self-defense when that other inmate came at him.
That's what it looked like to me.
My client believed he was in imminent danger when he made that turn, saw that guy in the corner that said, "What's up?" and he's coming at him.
He knows he did wrong.
Oh.
You haven't had a single shred of evidence to believe that Mr. Davis believed when he engaged in that confrontation that he was engaging in self-defense.
Chill out, Mark.
And ultimately, the jury bought the second soundbite there, that this was not self-defense. Davis's attorney had also tried to pin some of this on Metro, questioning why two men charged with murder were allowed to get so close to each other in a room like that. Now, this is a pretty serious felony, battery by prisoner. It carries a sentence of 1 to 20 years. Ultimately, it is now
1 to 20 years. Oh my gosh. I can't imagine that he'd get 20 just because they were fighting, but y'all see how this system works? Stay out, stay out, stay out, stay out of the system. Stay out of the system.
Battery by prisoner. It carries a sentence of 1 to 20 years. Ultimately, it is now up to the judge in this case to sentence Davis. And again, this has nothing to do with the Tupac case. That sentencing is set for later next month. We are live at the Regional Justice Center in downtown Las Vegas, and I'm David Charnes, 8 News Now.
And
all right, shout out to David. Let's see what else they have to say here.
Police arrested Davis in 2023. Now, he's remained in jail ever since. A trial for the murder charge in the Tupac Shakur case is not scheduled to begin until next spring.
Yeah, I think the reason that there's such a huge gap from the 1 to 20 is because it depends on, was there a weapon used? Who was the aggressor? What happened in between them fighting and stopping? Like, there's so many things that could fall under that 1 to 20 year gap. Insane. All right, let's get into the verdict being read from the judge. Again, this just seems like kind of BS in this case. Why was that inmate there in the first place? And if Keefe D knew what he was in there for, wouldn't you think his guard already would have been up? Either way, here we go. Let me skip ahead a little bit. You got Keefe D walking out in his pastor suit. And I thought his attorney did a good job.
That's everyone, Your Honor.
Thank you. Please be seated. Do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Has the jury elected a foreperson? That's Mr. Medina. Have the jurors reached a verdict?
Yes, sir.
Okay. Do we have the verdict?
That's crazy they found him guilty.
Thank you. Clerk will now read the verdict out loud.
District Court, Clark County, Nevada. the State of Nevada plaintiff versus Dwayne Keith Davis defendant. Case number C25389079-2, Department 4. Verdict. We, the jury, in the above entitled case, find the defendant, Dwayne Davis, as follows. Count 1, battery by prisoner. Guilty of battery by prisoner.
Dang.
We, the jury, in the above entitled case, find the defendant, Dwayne Davis, as follows. Count 2, challenge to fight. Guilty of challenge to fight. Dated this 9th day, April 2025, signed by Rodney Medina, foreperson. Ladies and gentlemen of the jury, is this your verdict as read? So say you one, so say you all.
Yes. All right, thank you. The clerk will now record the verdict in the minutes of the court. Does either party wish to have the jury polled?
No, Your Honor.
All right, thank you. Ladies and gentlemen.
How much time do y'all think he's gonna
for
get?
your service today. You are now released from your admonishment. You can speak to anyone about anything that has happened in the courtroom, including what has taken place in the jury deliberation room. I will make myself available to answer any questions you might have. You can go back into the jury deliberation room, even the alternates as well. Thank you.
All rise for the presence of the jury.
He said, man, this is a guy who loves to talk, though. I'm sure some of y'all have seen some of the interviews we talked about that Keefe D has done. He wrote a book. It's a guy that doesn't know how to shut up, to be honest. He needs to get 20 with his turtle self. Dang. Hey, y'all leave that man alone. He was just defending himself. Dang. Y'all are brutal.
Thank you. You can be seated. So the defendant is still going to continue to be remanded into custody on this case. The sentencing date will be, let's see, May 27th at 9 a.m. Does that
May
work for your
27th.
schedule?
Okay.
It does, Judge. I would request that the order be remanded without bail at this point.
Will be remanded without bail. Mr. Arnold.
Check that date.
Yes, take your time.
Look at him, look at this lawyer. He said, for real? He said, hey, talk to me. His lawyer said, hold on, shut up. Yo, what's going on, man? Thought you said I was gonna get bail. Who you texting? Why you asking her about lunch? Yo, somebody help me. Dang.
May 27th?
Yes.
Yes, I'm here.
Thank you. So then a matter will be referred to the Department of Parole and Probation for a pre-sentence investigation report and set for sentencing on May 27th at 9 a.m. Thank you. Have a great day.
His lawyer said, man, I got tea time. Go get yourself back in there and stay out of trouble.
Talk to the jury, let them know we're willing to talk to them. Only if they want to talk to them, we'll wait around for a few minutes to see if they want.
His lawyer's ready to go.
Can we have the IT switch the microphone back for the next trial?
He was trying. Yo, that lawyer does not care, man. Look at Keefe D. Dang, that's tough.
I'll just go grab the laptop so you can take that.
Sure.
Thank you.
And he got to change out of his suit and everything. Well, y'all let me know what you think in the comments in the chat. Did they get it right on this one? Tough position to be in. I mean, there's really no way you can win in this unless you just put your hands behind your back. But even that can see as aggressive depending on where you come from. So let me know what y'all think in the comments in the chat. Jeez, man. Y'all said, who said that about, you say his turtle self? Y'all are mean, man. Why'd you say that, April O'Neil? He's pissed and he wants to go home. His lawyer got booty call in 2 minutes. Oh my goodness. Lawyer's like, you already in here for life. What you want me to do? They both guilty. Stop the cap.
Stop the cap.
The guards had everything to do with that. Why they didn't lose their jobs. This BS needs to stop. No, they didn't get it right. I don't think they got it right either. There's some other videos we could watch and go through where they talk about what went down leading up to this situation, what happened during the situation, and maybe we'll get into that a little bit later. Y'all let me know if that's something that you want to look at. I'm trying to think. We might go a little bit of a different direction here. So let me do this. I think we're going to We're going to skip over one story I have for y'all. We'll go straight to Wendy Williams real quick. All right. And again, thank you to everyone who's liked the video so far, man. Over 100% of y'all liked the video. We got 400 of y'all in here. 448 of you have liked the video. I appreciate y'all. Thank you, thank you, thank you. Wow. What else did y'all say? He said, Shadow Fox said, he said, yo, dude, do something, man. His lawyer said, hey, I'm gonna go talk to the jury, man. It does not matter at this point. Keith could have died a free man if he kept quiet. He was out there doing podcasts. He was over there on Vlad. He wrote a book. I'm listening to the closing on TAY and defense is cooking. No tangible evidence, just hearsay. Yeah, Nikki, we're gonna get into closing arguments in a second. I don't think it's looking good for TAY, to be honest, but we will see what y'all think about it here in a second. All right. We've got some more news when it comes to Wendy Williams. So, as y'all know, we had the Honorable ASAP Joe, aka Joe Tacopina, on the channel. We did an interview with him. If y'all haven't seen that, make sure you go rewatch the interview, and I'll leave a link for you in the description. And the last thing we talked about was what was going on with Wendy Williams, her situation with her guardian, where she's being held, her mind state, all of that. And we're going to get into a little bit later what Joe Tacopina thinks about the situation. He is now officially representing Wendy Williams. So congratulations to our guy, Joe Tacopina, on there. She's definitely in great hands, and I'm happy for her on that. But TMZ just reported that Wendy Williams is having some more issues with her guardian. We're going to get into it here. All right. What did she say? Wendy Williams denied a dinner with her niece and lawyer. So much for Wendy Williams' guardian insisting Wendy is allowed to leave the confines of her assisted living facility to visit with family because the guardian just torpedoed a night out with Wendy's niece, according to sources with direct knowledge. Wendy planned a night out with her niece, Alex Finney, and her new lawyer, her new personal lawyer, Joe Tacopina. All right, shout out to ASAP Joe. They were going to have dinner at a New York City restaurant, that is, until Wendy's guardian, Sabrina Morrissey, put the kibosh on Wendy leaving the 5th floor of the facility, which Wendy calls a luxury prison. Interesting, since the lawyer of Morrissey recently sent TMZ a letter insisting Wendy was not being kept from her family and she could see them whenever she wanted. Yeah, right. Well, it seems clear that that's not the case. It is unclear why Wendy was denied the right to dine with Alex and Joe, but it may have something to do with Wendy's strong desire to end the guardianship, which of course the guardian wouldn't want, right? She has control of literally Wendy's entire life. Why would she want that to end? She doesn't want her to talk to Joe. Our sources say if the judge doesn't end the guardianship soon, Wendy will demand a jury trial and Joe will be her new trial lawyer. Oh man, I hope she can get out before then, but we know if Joe takes it to the trial, she's going to be okay. That would put Joe squarely in opposition to the guardian. That'll be one to see. As you know, Joe is a formidable force in a courtroom, most recently scoring a stunning win in the A$AP Rocky trial. And y'all let me know in the comments if you want to get Joe back to talk about this Wendy Williams situation again. I know he's happy to join the show again as well. We talked about it before, so I'll have to bring him up here if that's something that y'all want to see. We do know Joe and Alex are having dinner, and it's likely they're talking about strategy over pasta. Let's hear what Joe had to say about this situation. Shout out to TMZ for this.
So Wendy's retained you as her personal attorney. What's the next step? How do you get on the guardianship case, which is really the end goal here?
The end goal is to get her out of that draconian institution she's in, that she doesn't belong in, because she's not incapacitated in any way, shape, or form. She's in a ward where people don't know their names, where people don't know between a red light and a green light. I mean, she's in a place where, you know, people are dangerous to themselves. She's not. She can't leave there on her own to go get a cup of coffee. So
it's
the
so
goal
sad,
end game
man.
is to make sure she gets out of there. How it's done is honestly doesn't matter to me. Now, I spoke to Wendy at length yesterday. She wants me to represent her. I am representing her. Her family's asked me to represent her. I'm her personal attorney now. Doesn't mean I'm in the guardianship case yet, and I'm not, because the judge has to approve any lawyer coming in to the guardianship. So the bottom line is there's a process that's in play there. We are moving. We're making motions to make sure we're doing everything to get ourselves into the guardianship proceedings. And then we have other remedies if that doesn't work. If the judge, for some reason, doesn't allow us into the guardianship matter as Wendy's counsel of choice, which is almost sounds ridiculous, but they could try and argue that she's doesn't have the wherewithal, the abilities to pick her own counsel, which is obviously silly. But if they did, we'd take an interlocutory appeal, or we could go as far as doing something called an Article 78, which is actually suing the judge in a Supreme Court in New York State. So
and y'all know
we have
Joe
things
does
to
not
do,
play.
and we'll be doing them. There are certain rules once I'm in as a guardian in the guardianship case. There's gag orders in place and whatnot, so it'll change my ability to do things that we're doing right now. But I don't care about that. I care about just getting her out of there, and whether it's me or this other law firm or us as a team, she needs to be out of there. Every day she spends there is a travesty of justice, and any additional day she spends there is horrific. I speak to her almost daily, and it's just, I mean, you look at those videos, it's horrible. She's fine.
How do you go about getting her out of that facility when the guardianship, I mean, you'd have to go against the guardianship at this point or are you just trying to convince, is this a negotiation with the guardian to say, look, she clearly doesn't belong in there, and then you deal with the guardianship itself later?
No, it's all sort of under one umbrella, where the judge basically has to be convinced that she is not in need of a guardian. And the guardian sort of has to acquiesce. And it should be also supported by medical examinations, which Wendy has done very well on.
Yeah, and we've even seen with comments from the judge, it seems like this judge does not feel like Wendy's in a good place to make these types of decisions. Is holding a lot of her past against her, unfortunately. But it's just the nature of it. We've seen the judge talk about her current situation, decisions she's made, and I know Joe's going to get it done, but hopefully they don't face too much resistance here.
Look, she does not have frontal lobal dementia. She just doesn't. That's something that deteriorates over time, does not improve over time. And from 2024, when she was diagnosed with that, she was under a severe battle of alcoholism, and she was an alcoholic and is an alcoholic. She's sober now, but look on that TMZ piece that you guys produced with Harvey doing her interview, it was amazing. She was cognitive, she was articulate, she was Wendy. It's sad that this is happening, and there's I quite frankly question the motivations of people in this thing, but the bottom line is she needs to get out of there, and sooner rather than later. We have an ability, if the judges are going to let this happen, there is a mechanism where she's entitled to a jury trial. I hope it doesn't get that far. I hope a judge is going to evaluate her, look at the medical evaluations, listen to her, and say, okay, she's fine. She could go. I mean, this judge actually went as far at one point to say that, one of the reasons she thought she was incapacitated is because she repeatedly used the word, you know what I'm saying? You know what I'm saying? That phrase.
That's crazy, man.
That's crazy.
That's her.
That's her. And Harvey did a great thing. You guys did a great thing on that with your documentary, where you showed that Wendy has been saying that for 15 years on her show. That's one of her catchphrases, that and how you doing, right? So that's Wendy's speech mannerisms. That's not a indicia of mental defect, but that was actually used against her. So this is a scary thing. And a guardianship, when you're held in a facility, is a course of last resort. It's not meant to put a 62-year-old woman in there really against her will, who's able to communicate with her family, with her friends, have a conversation, have dinner. It's not meant for that. It's really a course of last resort where someone is a danger to themselves. That's not the case here.
All right, shout out to ASAP Joe up in the building. As I mentioned before, we know Wendy is good hands with Joe taking the lead on this. I'm glad to see she was able to get him on her team officially. I hope that he doesn't get too much pushback from this judge, because as Joe mentioned, we've already heard little things from the judge as to what she may feel about Wendy Williams and her entire situation. So hopefully they can get some things reevaluated. She just passed some recent tests with flying colors when it comes to her mental capacity. So moving forward, I think we'll see some good results. We'll have to wait and see. Y'all let me know what you think about this in the comments and in the chat. All right, shout out to the gang. I see y'all showing some love to ASAP Joe. Yeah, we'll bring him back up here. He said, please get Joe on the show. The Guardian can be recused. Yeah, I'll hit up Joe and see when he can get back up here for sure. And shout out to Joe, man. So such an amazing attorney, such an amazing person in general. He was thanking y'all as well for, the warm welcome that you gave him here in the community. And he said he enjoyed it. He'd be happy to come back and do another part 2 of the interview, because I still had so much I wanted to ask him about as well. So we'll definitely get into it. Shout out to ASAP Joe. Great. They have problems with Mr. Tacopina. He is going to roll out the Guardian. Yeah, the Guardian is just terrible. So the judge is biased. I believe so. I'm gonna be honest. From what I've heard from this judge and some of the quotes I've seen from the judge during these court proceedings, it seems like the judge is a little biased against Wendy and her mental ability. I mean, you heard taking something as simple as her saying, "How you doing?" or "You know what I'm saying." Come on, judge. It's sad to see. He knows their tricks and strategies. They will fail. Wendy will be free soon. Yep. Shout out to ASAP Joe. Shout out to Slim Life New Jersey in the building. Says, happy Friday, CEB family. Everyone enjoy your weekend. Much love. Thank you for the super chat. I appreciate you. Can ASAP Joe have the case moved? No, he's in New York, so he wouldn't need, he could. He talked about the process a little bit of filing a lawsuit against the judge and essentially having the judge recused. In this instance, there would have to be some very, very extenuating circumstances other than her just not understanding that "how you doing" is the thing you say, or "you know what I'm saying." So, I don't know. Bought and paid for by her husband, money motivated, first priority, new judge. It sounds like might need to happen. It really might need to happen. All right. So we were initially going to go into one more thing, but we got to move back to TAY, y'all, because closing arguments are underway, which we'll get into here in a second. But before we get into closing arguments with TAY, we've got to look at this testimony from, let me make sure this is the right one, from TAY, or not from TAY's, from the victim's mother. All right, so let's go ahead and get into it. If y'all haven't yet, please make sure you like the video on your way. And if you haven't yet, and I don't ask for y'all to subscribe often, but if y'all want to subscribe, go ahead and hit the subscribe button so you don't miss any time that we go live or drop a new video. All right, so let's get into this. Now, we are actually going to hear from the mother of Mark Anthony Saldivar. So she's going to get up on the stand and she's going to talk about her son and what he was into and some of the things that he was doing leading up to this tragic event. Here we go.
Can you speak? Just say. Hello? Can you hear me? All right, let me start. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes, I do. All right, you can lower your hand. Just make sure you keep your voice up so members of the jury can hear. And if you could state your name and spell your last name, please. Lucy Saldivar, Saldivar. All right, state your name, proceed.
Thank you, Your Honor. Ms. Saldivar, can you please introduce yourself to the jury?
Hello, my name is Lucia Saldivar. I'm Mark Saldivar's mom.
Dang, sad.
I just want to point to you and see this microphone in front of you.
Yes.
You can turn it like this if you're going to turn this way. Speak into that because you're just a little soft-spoken, okay?
Okay.
Because everybody all the way back there needs to hear you.
Okay.
Thank you, ma'am.
It's sad, man.
And
Imagine losing your child.
One, I believe you stated that your son is Mark Anthony Saldivar. Is that correct?
Yes.
And can you tell us something about Mark Anthony Saldivar, ma'am? Like, what type of person was he?
He was my youngest son. He was a good son. He never got in trouble. He was always happy.
try to help his friends in any way he can.
Okay. And you know, I know that's a brief thing that you told us, thank you, but, you know, did he have a certain passion that he really enjoyed?
Yes.
Oh, dang, I shouldn't laugh. That was not convincing at all. I'm not gonna lie. He was a good, and maybe she's nervous. He was a good son. He never got into trouble. He was always doing good things. He was very happy. He always helped me, and he took me to dinner, and he cut the grass whenever I asked him to. I mean, all right, come on, let's be for real now.
He did. He wanted to do photography.
And was that something that he did often?
Yes.
And, you know, would he want to do that for his occupation?
Yes.
And I'm going to show you what's been marked state exhibit number 142.
I'm not buying it.
Can you please tell me if you can identify 142 and 144?
Yes.
And what are those photos of?
My son, Mark Soderbergh.
And these are pictures, obviously, before he was murdered. Is that correct?
Yes.
Okay. And
I'm sorry, I'm going to object to the question, especially the phrasing of the question. That's it.
I can rephrase.
The objection will be sustained.
Motion to instruct the jury to disregard.
All right, ladies and gentlemen, you disregard that last question.
Motion for Mr.
Denied.
Thank you. May I proceed, Judge? Yes. Thank you. In state exhibit number 142, that picture of Mark, what does he have hanging around his neck?
His camera.
And this camera in this photo, was this one of his, well, did he have many cameras or just one camera?
He had a few, but that's the one that he used most.
And that's, I'm sorry, that's the one he used the most?
That's the last one he got, so yeah.
Okay. From this picture, well, let me go ahead and enter stating, I'll tender to defense to any objections of state 142 and 144.
Nabodar?
Yes.
Ms. Saldivar, good afternoon.
Good afternoon.
The photograph that shows the camera in 142, on the last thing that we saw, Mark, he left on foot from your house, correct?
Yes.
And you didn't see what he left with, right?
Just his backpack.
Okay. Your Honor, I would just object to 142 on the basis that it's under 403, cumulative, and there's a lack of foundation.
All right, can I see State's Exhibit 142, 144, please? Right, and defense, you said your objection is to which one?
May we approach?
Yes.
So they're gonna approach here. They don't want to include the picture.
I'm going to show you again what's marked state exhibit number 142. It's that camera on there. One, do you know if Mark, the day he went missing, that you never spoke to him again, do you know for a fact if he took that camera?
I think so. I couldn't find it in his room.
You could not find it in his room?
No.
Did you ever see that camera again?
No.
Your Honor, at this time, the state would move to enter state exhibit number 142 into evidence and tender to defense for any objections.
Same objections and speculation.
All right, objection is over with State's Exhibit 142 is admitted.
Thank you. May I publish to the jury?
Yes.
Now, this is state exhibit number 142, Ms. Salvador. Is this the camera that was mentioned during your testimony just previously?
Yes, sir. Yes.
And this is the camera that Mark owned?
Yes.
And this is the camera that he
There's
used
Mark.
for photo shoots. Is that
Yes.
accurate?
Yes.
Thank you.
Dang.
And then state exhibit number 144, is that another photo of Mark?
Yes.
Thank you. Now, was there anything else about Mark that, for instance, at state exhibit number 144, that he had a passion or a collection of objects?
Yes.
What did he collect?
He collected gemstones.
Gemstones?
Yes.
And if I'm pointing at 144, it looks like a necklace. Was that something what you're calling a gemstone type
Yes.
thing? And was that, I guess, a very lay term, just a rock?
Right.
Okay, thank you. Now, on April 23rd, 2017, did you see your son that day?
Yes.
And can you just describe, if you can remember, obviously that day, when you saw him and what y'all were doing throughout the day?
Well, in the morning we were working at the yard, on the yard. We came in, he took a shower, got ready, and he told me he was going to go do a photo shoot. And I asked him if he needed a ride, and he said no, that somebody was going to pick him up.
And you stated a photo shoot. Did
Dang,
you
that's
have any
tough.
indication of what type of photo shoot?
He didn't tell me. He did tell me he was a upcoming rapper or something like that.
Hearsay confrontation.
All right, with regards to hearsay, that objection will be sustained.
Motion to instruct.
Is that really hearsay?
All right, ladies and gentlemen, you're to disregard that last statement.
I mean, I'm not going to argue with Judge Boyd. It's the last judge I'm arguing with.
You stated just now also that your son stated that somebody was going to pick him up.
Yes.
And on that particular day, did you advise him of anything before he left?
Objection calls for hearsay.
Leading.
Did you advise him of anything before he left?
I just told him to be safe, be careful.
I'm sorry?
To be safe and be careful.
Did you give him anything?
He asked me if I had any money, and I told him I only had $10, and so I gave it to him. He leaned over and got the $10, gave me a kiss. He said, "I love you."
Hearsay calls for hearsay and confrontation.
Nobody's sustained.
Yeah, come on. We got to do better
When
than
he
this.
left, do you remember him taking anything with him?
Just a backpack.
Just a
that I
backpack?
recall. The
I'm sorry?
backpack. Just a backpack that I recall.
And do you remember what he was wearing by any chance?
It was black, gym shorts. It was a vest, fleet. I think it was gray or blue, and he had some shoes, and the socks had prints on it.
And, you know, this is a while back. This is 7 to 8 years ago. So why do you remember that?
I don't know. I just do. I remember exactly what he was wearing.
So this backpack, if you know, do you know the contents of the backpack?
I didn't know why it was hearsay
No, sir.
either.
Oh, it was black. That's all I know.
But your previous testimony was he was leaving to be picked up to do the photo shoot.
Yes.
And did you have any contact with Mark after he left at that point?
No.
By text message or calling? or
I
anything?
texted him, and he replied. And then after that, I kept texting him, and he didn't reply anymore.
And do you remember approximately what time he left?
It was
or
it was after 4:30, I think.
After 4:30?
Yes.
And related to Mark, were you contacted by anybody other than Mark?
The detective.
And a detective with San Antonio Police Department?
Yes.
And did they come to your house?
Yes, he did.
And did they speak to you?
Yes.
And on another day, did you also have contact with this detective?
Over the phone.
Did you ever view a photograph associated with this case of a wallet?
Yes.
She's holding up though. Shout out to Mama Salazar. It's tough.
I'm going to show you what state exhibit number 145. Now, is this a copy of a photo and also writing that you saw back on May 10th, 2017?
Yes.
And whose wallet is in that photo?
Mark's.
How do you know that this black wallet is Mark's?
Because I gave it to him, I bought it for him, I gave it to him, and I got it because of that little tassel it has.
The tassels it has. Now, is that the same photo that's state exhibit number 78?
Yes.
And Your Honor, at this time, did you write something on this photo?
Yes, it says this is the wall.
All right, the objection to hearsay will be sustained.
What I'm going to ask you is, do you recall how many, when did you give this wallet to Mark?
It had been probably about a couple of months prior.
Okay. Judge, oh no, okay, we'll just stick this here. But that state exhibit number 78 is the exact same copy of 148, is that correct?
Yes.
Okay, thank you. That is the wallet of your son, is that correct?
Yes.
Do you know where this wallet was found, if you know?
No, I don't.
I'm going to show you what's marked state exhibit number 107.
Yes.
Is this that same wallet?
Yes.
Oh, that's so sad. We're showing her the wallet that she gave him. Dang. For nothing.
So, Ms. Salvador, I want to ask you, do you know a Joanna Reyes?
No.
Do you know a Tamar McIntyre?
No.
Or do you know a Jalen Bell?
No.
Or what about a Jeremiah Rodriguez?
No.
Yeah, Mark was the
I'm just
mark.
going to show you what's been marked state exhibit
That's
number
it.
42.
Dang.
I just want you to look at this picture and tell me if you're able to identify the person that I show you in this picture. State exhibit number 42.
I'm going to object to this question. We filed a stipulation on this exact issue.
Objection is over.
And I showed you that picture. Did you recognize the individual in that picture?
Yes.
Who is that?
My son, Mark Anthony Salvador.
Dang.
Thank you, ma'am. We'll pass it.
Yes.
That's sad. So
After
sad.
Ms. Salvador, I just have one question for you. Did Mark have any other plans, or appointments, or responsibilities that day, that afternoon that might have conflicted with the photo shoot
No.
he told you about?
No.
Thank you, ma'am. Pass the witness.
No further questions for this witness, Your Honor?
All right, is she excused?
Please.
Excused?
Yes, Your Honor.
All right, the rule has been revoked. You're not allowed to discuss your testimony with anybody during the pendency of this trial.
Okay.
You may sit down.
Thank you.
All right, Mama Saldivar, she did her thing. She held her own. That's sad, man. She was just a little bit shaky at the beginning. She was probably trying to keep it together. Losing a child, I cannot imagine. And then you have to think she asked him if he needed a ride, and he said no. Ah, man. I'm just as a parent, I'm thinking she's probably feeling some guilt about that. I mean, she could have insisted, nope, I'll just take you. Don't worry about it. Now, there may have been a reason, especially considering that there were certain people there that he didn't want his mother to go. But at the end of the day, still a sad situation. Hopefully, Mark will get justice in this case, but y'all have to let me know what y'all think that would look like in the comments and in the chat. All right, we're going to keep it moving because it is time. It's finally time. We're here for closing arguments. I cannot believe it. A 9-day trial. Let me go ahead and update this headline. And we are going to get to closing arguments. So it looks like, let me double check here. And before I get to this, let me see what y'all are saying. Robbed and killed that man over nothing, over a camera. He wasn't a millionaire or a wealthy guy. Low lies that had nothing to lose. Getting the mom is so smart by the state because you have a face to attach to the crime. When you go in to deliberate, you have to think about the mom now. Absolutely. Sad people are losing their lives for nothing. Happens far too often. So what we're going to do is we're going to go ahead and get ready for closing arguments. Obviously, we're going to have to hear some instructions to the jury from the Honorable Judge Stephanie Boyd. Again, if y'all haven't checked out our YouTube channel, please go check it out. She does a great job over there as well. Here we go. And y'all actually give me 1 second. Let me do this right quick. And that is on me. For some reason, we can't hear
all of the evidence that you're going to hear in the case. All right, everyone, please be seated. All right, ladies and gentlemen, you've heard all of the evidence that you're going to hear in the case at this time. What I'm going to read to you is the charge of the court. It's the jury charge. You do not have to memorize it. The original will be sent back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant Tamar McIntyre stands charged by indictment with the offense of capital murder alleged to have been committed on or about the 23rd day of April 2017 in Bexar County, Texas. The defendant has pleaded not guilty. 1. The law regarding murder. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. 2. The law regarding capital murder. Our law provides that a person commits the offense of capital murder when such person commits the offense of murder by intentionally causing the death of an individual in the course of committing or attempting to commit the offense of robbery. 3. The law regarding manslaughter. Our law provides that a person commits the offense of manslaughter if he recklessly causes the death of an individual. 4. The law regarding robbery. Our law provides that a person commits the felony offense of robbery if, in the course of committing theft, as defined hereinafter, and with intent to obtain or maintain control of the property, he intentionally, knowingly, or recklessly causes bodily injury to another, or he intentionally or knowingly threatens or places another in fear of imminent bodily injury or death. 5. The law regarding theft. Our law provides that a person commits the offense of theft if he unlawfully appropriates property with the intent to deprive the owner of property. 6. Applicable statutory definitions. Appropriation and appropriate mean to acquire. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful, right, if it is without the owner's effective consent.
Seems pretty straightforward. Uh-oh, what happened? Hold on. I messed the whole thing up. Judge Boyd was up there cooking. Let me see. Uh-oh, y'all give me 1 second. Give me 1 second, y'all. Oh, Kyrese is in the building too. What's up, Kyrese? Y'all are saying, yep, straightforward, definitely second-degree felony murder. Y'all are saying, oh my goodness. Ready to get him up out of there already.
Is unlawful if it is without the owner's effective consent. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. A deadly weapon means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether expressed or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion of burning substance or any device readily convertible to that use. In the course of committing an offense means conduct that occurs in an attempt to commit, during the commission, or in immediate flight after the attempt or commission of the offense. Individual means a human being who is alive. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 7. Definitions of intentionally, knowingly, and recklessly. A person acts intentionally or with intent with respect to result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. A person acts recklessly or is reckless with respect to the circumstances surrounding his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 8. The law regarding parties. Our law provides that a person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another, which he is criminally responsible, or by both. Each party to an offense may be charged with the commission of the offense. Mere presence alone will not make a person a party to an offense. A person is criminally responsible for an offense committed by the conduct of another if acting with intent to promote or assist the commission of the offense he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense.
Sounds
9.
like it might be the
The
case.
law regarding an accomplice witness. You are instructed that an accomplice witness, as the term is here in use, means any person connected to the crime charged as a party thereto, and includes all persons who are connected with the crime as such parties by unlawful act or omission on their part, transpiring either before or during the time of the commission of the offense, and whether or not they were present and participated in the commission of the crime. You are instructed that a conviction cannot be had upon the testimony of an accomplice witness's testimony unless the jury first believe that the accomplice witness testimony is true and that it shows the defendant is guilty of the offense charged against him. And even then, you cannot convict unless the accomplice witness testimony is corroborated by other evidence tending to connect the defendant with the offense charged, and the corroboration is not sufficient if it merely shows the commission of the offense. The witness, Joanna Reyes, is an accomplice if an offense was committed, and you cannot convict the defendant upon her testimony unless you first believe that the portion of her testimony that ascribed guilt to the defendant is true and shows that the defendant is guilty as charged. And then you cannot convict the defendant upon said testimony unless you further believe that there is evidence in the case outside the testimony of Joanna Reyes tending to connect the defendant with the offense committed. If you find that an offense was committed and the corroboration is not sufficient if it merely shows the commission of the offense, and then from all of the evidence you must believe beyond a reasonable doubt that the defendant is guilty of the offense charged against him. 10. Self-defense and defense of third person or persons. You are instructed that it is a defense to the prosecution if the conduct of the defendant was justified by the law of self-defense or defense of a third person or third persons. You are instructed that a person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. The use of force against another is not justified, 1, in response to verbal provocation alone. Just one moment.
Hey, I feel you, Judge Boy. Get it together.
2, if the actor provoked the other's use or attempted use of unlawful force, unless A, the actor abandons the encounter or clearly communicates to the other his intent to do so, reasonably believing he cannot safely abandon the encounter, and B, the other nevertheless continues or attempts to use unlawful force against the actor. A person is justified in using deadly force against another, 1, if the person will be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force.
Y'all think the deadly force was necessary?
Stop the cap.
Eesh.
The actor's belief that the deadly force was immediate necessary is presumed to be reasonable if the actor, 1, knew or had reason to believe that the person against whom the deadly force was used, A, unlawfully and with force entered, or was attempting to enter unlawfully with force the actor's occupied habitation, vehicle, or place of employment or business. B, unlawfully and with force removed or was attempting to remove unlawfully and with force the actor from the actor's habitation, vehicle, or place of business or employment. Or C, was committing or attempting to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. 2, did not provoke the person against whom the force was used. And 3, was not otherwise engaged in criminal activity or other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. The presumption of a reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment. A person, 1, who has the right to be present at the location where the deadly force is used, and 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time of the deadly force is used, is not required to retreat before using deadly force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of force is necessary, a finder of fact may not consider whether the actor failed to retreat. A person is justified in using deadly force against another to protect a third person or persons if 1, under the circumstances as he reasonably believes them to be, the actor will be justified under the law of self-defense, as instructed above, in using deadly force to protect himself against the unlawful force he reasonably believes to be threatening the third person, a person he seeks to protect. And 2, the actor reasonably believes that his intervention is immediately necessary to protect the third person or persons. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means serious bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. You're instructed that the defendant is not required to prove the justification, defense of self-defense, or defense of the third person or persons. The state must prove beyond a reasonable doubt that the defendant was not justified in his actions. Thus, even if you unanimously find beyond a reasonable doubt that the defendant has committed an offense, as instructed herein, the state must still prove beyond a reasonable doubt that the conduct of the defendant was not justified. 11, capital murder is charged in the indictment. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of April 2017 in Bexar County, Texas, the defendant, Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes, did intentionally cause the death of an individual, namely Mark Anthony Salvador, by shooting Mark Anthony Salvador with a deadly weapon, namely a firearm. Tamar McIntyre either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes was in the course of committing or attempting to commit the offense of robbery of Mark Anthony Salvador, then you will find the defendant, Tamar McIntyre, guilty of the offense of capital murder as charged in the indictment. You will not consider paragraphs 12 through 15. But if you do not so believe, or if you have a reasonable doubt thereof, then you will acquit the defendant of the offense of capital murder as charged in the indictment, say by your verdict not guilty of the charge offense of capital murder, and proceed to paragraph 12 to consider whether the defendant is guilty or not guilty of the lesser included offense of murder. 12, lesser included offense of murder. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of April 2017 in Bexar County, Texas, the defendant, Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes, did intentionally or knowingly cause the death of an individual, namely Mark Anthony Salvador, by shooting Mark Anthony Salvador with a deadly weapon, namely a firearm, or the defendant Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes with the intent to cause serious bodily injury to an individual, namely Mark Anthony Salvador, did commit an act clearly dangerous to human life that caused the death of Mark Anthony Salvador by shooting Mark Anthony Salvador with a deadly weapon, namely a firearm, then you will next decide whether Tamar McIntyre was justified under the law of self-defense or defense of a third person or persons.
Do y'all think there is one juror who's questioning whether this was self-defense or not? I don't think so, but hey, y'all, there could be one of y'all that think there is a case it could be. Let me know.
McIntyre was justified under the law of self-defense or defense of a third person or persons. You will skip over paragraph 13. Do not consider the lesser included offense of manslaughter, but instead proceed to paragraph 14. But if you do not so believe, or if you have a reasonable doubt thereof, then you will acquit the defendant of the lesser included offense of murder, say by your verdict not guilty of the lesser included offense of murder, and proceed to paragraph 13 to consider whether the defendant is guilty or not guilty of the lesser included offense of manslaughter. 13. Lesser included offense of manslaughter. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of April 2017 in Bexar County, Texas, the defendant, Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes, did recklessly cause the death of an individual, namely Mark Anthony Salvador, by shooting Mark Anthony Salvador with a deadly weapon, namely a firearm, then you will next decide whether Tamar McIntyre was justified under the law of self-defense or defense of a third person or persons. Skip over paragraph 14 and proceed to paragraph 15. But if you do not so believe, or if you have a reasonable doubt thereof, then you will acquit the defendant of the lesser included offense of manslaughter and say by your verdict not guilty of the lesser included offense of manslaughter, and do not consider paragraphs 14 and 15. 14. Justification defense as to the lesser included offense of murder. Keeping in mind the instructions given in paragraph 10 on the justification defenses of self-defense and defense of a third person or persons, if you find from the evidence beyond a reasonable doubt that the defendant, Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes, committed the lesser included offense of murder as instructed in paragraph 12, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1. Tamar McIntyre reasonably believed, or is presumed to have reasonably believed, as viewed from his standpoint, that Mark Anthony Salvador was using or attempting to use unlawful deadly force against Tamar McIntyre and or Jalen Bell and or Jeremiah Rodriguez and or Joanna Reyes, and 2. Tamar McIntyre reasonably believed, or is presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself and or Jalen Bell and or Jeremiah Rodriguez and or Joanna Reyes against Mark Anthony Salvador's use or attempted use on unlawful deadly force, and 3. Tamar McIntyre's use of deadly force was not in response to verbal provocation alone, and 4. Tamar McIntyre did not provoke Mark Anthony Salvador's use or attempted use of unlawful force, or if he did, he abandoned the encounter and clearly communicated to Mark Anthony Salvador his intent to do so, reasonably believing he could not safely abandon the encounter, and Mark Anthony Salvador nevertheless continued or attempted to use unlawful force against Tamar McIntyre. Then you will find in favor of Tamar McIntyre on his claim of self-defense and or defense of third person or persons, and acquit the defendant, Tamar McIntyre, of the lesser included offense of murder, and say by your verdict not guilty of the lesser included offense of murder as instructed in paragraph 12. Do not complete the verdict form for the lesser included offense of manslaughter and skip to paragraph 15. However, if you find from the evidence beyond a reasonable doubt that the defendant, Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes, committed the lesser included offense of murder as instructed in paragraph 12, and you further find from the evidence beyond a reasonable doubt that 1. Tamar McIntyre did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that Mark Anthony Salvador was using or attempted to use unlawful deadly force against Tamar McIntyre and Jalen Bell and Jeremiah Rodriguez and Joanna Reyes, or 2. Tamar McIntyre did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself and Jalen Bell and Jeremiah Rodriguez and Joanna Reyes against Mark Anthony Salvador's use or attempted use of unlawful deadly force, or 3. Tamar McIntyre's use of deadly force was in response to verbal provocation alone, or 4. Tamar McIntyre did provoke Mark Anthony Salvador's use or attempted use of unlawful force, and he did not abandon the encounter, and he did not clearly communicate to Mark Anthony Salvador his attempt to abandon the encounter, and Mark Anthony Salvador did not continue or attempt to use lawful force against Tamar McIntyre. Then you will find against Tamar McIntyre and his asserted justification defenses of self-defense and defense of third persons. And you will find the defendant, Tamar McIntyre, guilty of the lesser included offense of murder as instructed in paragraph 12. Do not complete the verdict form for the lesser included offense of manslaughter and skip to paragraph 15.
Yeah, I don't know.
15.
Not looking great.
Justification defenses as to the lesser included offense of manslaughter. Keeping in mind the instructions given in paragraph 10 on the justification of self-defense and defense of third person or persons, if you find from the evidence beyond a reasonable doubt that the defendant, Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes committed the lesser included offense of manslaughter as instructed in paragraph 13, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Tamar McIntyre reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that Mark Anthony Salvador was using or attempted to use unlawful deadly force against Tamar McIntyre and or Jalen Bell and or Jeremiah Rodriguez and or Joanna Reyes, and 2, Tamar McIntyre reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself and or Jalen Bell and or Jeremiah Rodriguez and or Joanna Reyes against Mark Anthony Salvador's use or attempted use of unlawful deadly force, and 3, Tamar McIntyre's use of deadly force was not in response to verbal provocation alone, and 4, Tamar McIntyre did not provoke Mark Anthony Salvador's use or attempted use of unlawful force, or if he did, he abandoned the encounter and clearly communicated to Mark Anthony Salvador his intent to do so, reasonably believing he could not safely abandon the encounter, and Mark Anthony Salvador nonetheless continued or attempted to use unlawful force against Tamar McIntyre. Then you will find in favor of Tamar McIntyre on his claim of self-defense and or defense of a third person or persons, and acquit the defendant, Tamar McIntyre, the less included offense of manslaughter, and say by your verdict not guilty of the less included offense of manslaughter as instructed in paragraph 13. However, if you find from the evidence beyond a reasonable doubt that the defendant, Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and Joanna Reyes committed the lesser included offense of manslaughter as instructed in paragraph 13, and you further find from the evidence beyond a reasonable doubt that 1, Tamar McIntyre did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that Mark Anthony Salvador was using or attempting to use unlawful deadly force against Tamar McIntyre and Jalen Bell and Jeremiah Rodriguez and Joanna Reyes, or 2, Tamar McIntyre did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself and Jalen Bell and Jeremiah Rodriguez and Joanna Reyes against Mark Anthony Salvador's use or attempted use of unlawful deadly force, or 3, Tamar McIntyre's use of deadly force was in response to verbal provocation alone, or 4, Tamar McIntyre did provoke Mark Anthony Salvador's use or attempted use of unlawful force, and he did not abandon the encounter, and he did not clearly communicate to Mark Anthony Salvador his intent to abandon the encounter, and Mark Anthony Salvador did not continue or attempt to use unlawful force against Tamar McIntyre. Then you will find against Tamar McIntyre on his asserted justification defenses of self-defense and defense of third person and third persons, and you will find the defendant, Tamar McIntyre, guilty of the lesser included offense of manslaughter as instructed in paragraph 13. 16. You are instructed that if there is any evidence before you in this case regarding the defendants having committed an act of misconduct or offense other than the offense alleged against him in the indictment in this case, you cannot consider said evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such offense or act of misconduct, if any were committed, and even then you may only consider the same in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, if any, of the defendant, or for the impeachment of the defendant in connection with the offense, if applicable, or to rebut a defensive theory, if any, alleged against him in the indictment in this case and for no other purpose.
No, these
17.
Are good instructions.
Our law provides the defendant may testify on his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that facts cannot be taken as circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever or circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict.
Didn't say Snapchat.
Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless included in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of the law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After arguing with counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to the charge and signing his or her name as presiding juror. You are exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any questions you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the deputy Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. So, ladies and gentlemen, each side is going to have 30 minutes to present their closing arguments to you. If anyone needs a break, now we can do a brief break for you now, or either both sides are going to proceed with their closing arguments. All right, state, you may proceed.
Here we go. So now we've got closing arguments from the state. Boy, who do you think is winning right now? Y'all let me know in the comments in the chat. This closing arguments from the state, I think, is going to be pretty straightforward and probably predictable. We'll see. Only 30 minutes.
In the world of Tamor McIntyre, Mark Anthony Saldivar was a nobody. Tamor McIntyre took Mark's life in that Chick-fil-A parking lot. He discarded him there like a piece of trash, and then when he got to El Potosino restaurant, he celebrated his slaying. Ladies and gentlemen, Mark Anthony Saldivar was a somebody. He was a good son, a brother, a friend, a photographer, and tragically, he was the victim of a capital murder committed by the hands of that defendant sitting right there. Dang. And we're going to talk about the law that supports that. Now, in your jury form, you have the lesser included offenses of manslaughter and murder. Now, manslaughter is if a defendant recklessly causes the death of an individual. Murder is when the defendant intentionally or knowingly causes the death of an individual, or the defendant intended to cause serious bodily injury and committed an act clearly dangerous to human life that causes the death of an individual. Now let's talk about the mental states. Intentionally is legally defined as a conscious objective or desire of the defendant. Knowingly means that the defendant was aware of the nature of his conduct and the circumstances that existed. Ladies and gentlemen, this is not a manslaughter case. The defendant did not act recklessly. An example of manslaughter would be somebody waving around a firearm and they believe the safety is on and it goes off and kills somebody. That's not what happened here. The elements of capital murder. The state has proved these elements to you beyond a reasonable doubt. You heard multiple witnesses testify that this offense occurred on April 23rd, 2017. It occurred in that Chick-fil-A parking lot in Bexar County, Texas. You heard testimony that the defendant, Tamor McIntyre, was the shooter and that he was committing a robbery when he took Mark Anthony Saldivar's life, intentionally, shooting Mark Anthony Saldivar with a firearm. Ladies and gentlemen, the law doesn't require you to be a mind reader. You can infer intent from words and circumstances and facts that surround the offense. So let's look at that. The defendant acted intentionally. He had his firearm displayed from that stoplight at McCullough. He had his firearm displayed the whole time to Chick-fil-A, and he opened his door, leaned half in and half out, and shot Mark Anthony Saldivar. Those are intentional acts. Now, regarding the robbery. Robbery starts at theft. Theft is the unlawful appropriation of another's property, and it is unlawful if you do not have the consent of the owner. What are the facts that prove theft here? You heard Lucy Saldivar testify that she gave her son Mark $10 before he went in that black Kia Forte. The physical evidence that supports the theft is Mark's wallet being at the Mexican restaurant. You see Jalen Bell putting on Mark's backpack at the Mexican restaurant, and Jalen Bell discarded Mark's phone there in the Chick-fil-A on their way out of the Chick-fil-A parking lot. Further, you heard Hester Rogers testify that the back passenger was yelling for help after being forced out of the vehicle. And Joanna Reyes testified that Tamor made the demand for Mark's backpack, Mark refused to give it up, and Tamor had possession of the backpack when Mark was forced out of the vehicle. And Joanna further testified that at the Mexican restaurant, Jalen Bell was mad because there was only $10 in the wallet. Now, how do we get to robbery? It is committing the theft while causing bodily injury to the victim to maintain control or retain control of the property. Ladies and gentlemen, you've heard multiple witnesses testify to that. And the photos from the ME, you saw the knot that Mark had on his forehead. You saw the contusions that he had near his nose and his mouth. That proves robbery. You heard multiple witnesses testify. Ashley Buenteo testified the front passenger used the handgun to strike the back passenger. Paul Caballero testified that the front passenger was fighting the back passenger. Hester Rogers testified that the front passenger was brandishing the firearm while fighting the back passenger. And Joanna Reyes testified that Tamor beat Mark and took possession of Mark's backpack. Now I want to talk to you about the law of parties. Our law provides that a person is criminally responsible as a party to the offense if it's committed by his own conduct or the conduct of another. Jalen Bell and the defendant fled San Antonio with Mark's belongings, and this defendant, even though we have proved that he is the shooter, should you choose to not believe that, he is still criminally responsible for what happened in that car and for the death of Mark Anthony Saldivar, because he was an active participant in the beating and taking of Mark Anthony Saldivar's property. Now, when you retire to the jury room, if you find the defendant guilty of the offense of capital murder, your deliberations stop there. If you do not find him guilty of capital murder, then you would proceed to the lesser included offenses of murder and manslaughter. There are possible defenses to murder and manslaughter, and we'll talk about those. They're in the jury charge. It's self-defense and defense of a third person. Now, just because these affirmative defenses were submitted to you does not mean that the court is indicating anything to you, or that it's just that the defendant is entitled to those affirmative defenses, and that's why they're in the charge. Now let's talk about self-defense. A person is justified in using force against another when and to the degree the person reasonably believes that the force is immediately necessary to protect himself against the other person's use or attempted use of unlawful force, okay? A reasonable belief is a belief that's held by an ordinary and prudent person. The use of force in this case was not justified for many reasons. One, Mark was not using unlawful force against the defendant. He was merely trying to obtain his belongings back. There's no evidence that Mark ever injured the defendant or even engaged with him in a physical fight.
Oh, objecting during closing. Wow.
Furthermore, the defendant provoked. If you do find that Mark did use some type of force against the defendant, that force was provoked by the defendant, okay? The defendant is the one who put all of these acts in motion. And the defendant never abandoned his robbery of Mark Anthony Saldivar. And I'll tell you what abandonment would have looked like. Defense is gonna get up and argue, oh, the gun was just up in the air, oh, the gun was put away and then taken out again at the Chick-fil-A. No. What abandonment would have looked like in this case is giving Mark his things back and driving off. But that's not what happened. And you see that in the Chick-fil-A video. Now, talking about deadly force, it's pretty much, thank you, Judge. It's pretty much the same as what I just described, except the person that the defendant is acting against has to be using or attempting to use unlawful deadly force. Mark Anthony was not using any deadly force against the defendant. And the defendant does not get the presumption of reasonableness because he provoked Mark, and the defendant was engaged in criminal activity, and that is that robbery. A person is justified in protecting a third party if they believe, or if they would have been justified in using self-defense themselves, which we've already established that the defendant was not entitled to. And the use of deadly force was not justified in this case because Mark was not using deadly force against anyone in the car. They were all using deadly force against him.
That's what it sounds like.
Now, you all heard many witnesses in this case, and you're the exclusive judges of the facts proven, the credibility of the witnesses, and the weight to be given to the testimony. Now, I want to talk to you about the accomplice witness rule. Now, if you believe that Joanna's testimony naming the defendant as the shooter is true and shows the defendant guilty, you have to further believe that there is other evidence in the case to substantiate what her testimony was. And at that point, you can then find the defendant guilty. So let's talk about the other evidence in the case that tends to connect the defendant with the offense committed. The 911 calls, the lay witness testimony that you've heard. And defense is gonna get up here and they're gonna tell you, well, there were inconsistencies. Ladies and gentlemen, that's normal. There were multiple witnesses in this case, but they were not consistent about the important parts of this case. Who had the gun and who was in the front passenger. And they're gonna argue, thank you, Judge. They're gonna argue about the race. Some people said, oh, it was all Hispanics. I urge you to consider where the witnesses were. Elizabeth Adams did say she believed that the occupants of the black Kia Forte were Hispanic. She was standing in the Doubletree parking lot. Everybody that was in the vicinity, Hester Rogers, who was standing right there on the curb, described him as a medium-skinned black male, and the occupants of the car, Ashley Buenteo and her uncle, described a black male as well. The Chick-fil-A video, the El Potosino video, the letter in the clothing in the trunk, the phone records, and the digital evidence all corroborate and tend to connect the defendant to this case and being the shooter in this case. The blue phone that was found in the front passenger glove compartment. Ladies and gentlemen, that digital evidence is telling you who is the owner of that phone. TAY-K47 iPhone and TAY-K47U at iCloud.com. That's the owner of that phone. Now, you have in State's Exhibit 141 phone records from Joanna Reyes's phone. And I want you to take a look at those, because what you will find is if you compare the phone records from Joanna to the call logs in the defendant's phone, which is State's Exhibit 140, you're going to see some overlap, which corroborates Joanna. That first phone number up there was last called in the defendant's phone on March 11th of 2017. The defendant had communication with that phone number 6 times. Beginning on April 23rd, 2017, Joanna's phone calls that number 20 times. The next number, the defendant had communication with that number at least 43 times, and the last call was on March 8th of 2017. Beginning on April 25th of 2017, you'll find that number 8 times in Joanna's phone records. And that last number, the defendant had over 80 interactions and last called on March 8th of 2017, and there's 14 calls from Joanna's phone beginning on April 20th of 2017. All of those things corroborate Joanna. Further, in that blue iPhone, there's a picture of the defendant wearing the slides that were in the car and are pictured in State's Exhibits number 126. Ladies and gentlemen, at this time, your sole duty is to determine guilt or innocence in this case. The state is not required to prove our case beyond all doubt, just beyond reasonable doubt, and we have proven our case to you.
What do y'all
think? You are not to let bias,
agree?
prejudice, or sympathy play any part in your deliberations, and you have taken an oath to render a true verdict according to the law and the evidence in this case. Ladies and gentlemen, that verdict is finding the defendant guilty of capital murder. Thank you.
Wow, short, sweet, and to the point. Dang, they are not playing around. She said, listen, guys, you heard the testimonies. You saw the evidence. Get this dude up out of here. Oh, my goodness. Did somebody take the time? We should have marked the time to see how long that took. Let me know what y'all think about this in the comments in the chat. Now, we're going to move forward and we're going to hear from the defense and see what they have to say. I can imagine the defense is going to take a little bit longer than the prosecution did. Here we go.
All right, defense. Just a moment to switch. Please the court, opposing counsel, ladies and gentlemen, thank you all for the patience that you've given us and the sacrifice of your time. This is an extremely hard decision. It might be the most grave and serious thing that you consider, deciding the guilt or innocence of someone charged with capital murder. Taylor McIntyre is not guilty. He's not guilty of capital murder. He's not guilty of murder. He's not guilty of manslaughter. And the reason for that is very simple. If you're going to charge someone with that kind of an offense, if you're going to take their liberty away from them, then you have to do it right. You have to do the work. And as this case clearly demonstrates, the work wasn't done. The investigation was faulty, it was incomplete, and by and large, I think it could be summarized as the detective looking at it all and going, good enough. It's not good enough, and you all need to insist on more. If you recall the testimony of Detective Juarez and my cross-examination of him, I think I've given you a clear roadmap about what this case is about and what it isn't about. We all understand that there's a pool of physical evidence and there is testimony conflicting from different innocent bystanders. That information is not enough to convict anyone of a crime. None of the people that were in that car could be convicted on the physical evidence alone that was provided. And everything else that flows from this is the bought and paid for testimony of the accomplice witness, Joanna Reyes. And there is not sufficient corroboration. The law prevents you from convicting Mr. McIntyre solely on the testimony of that accomplice.
That's a good point.
Let's talk about the physical evidence.
Taking shots at
We
the
know that
stripper.
there's a 9mm shell casing found outside of the Chick-fil-A. We know that we have a dead body who died from a gunshot wound. We don't have a bullet. At the very basic core fact, the state can't actually demonstrate that that 9mm shell casing and the death are connected. We have gunshot residue on the deceased's hands. We do know that a 9mm handgun was seized off of Jalen Bell in Dallas a few weeks after the shooting. We have a black four-door Kia with a shattered windshield. We have some grainy surveillance footage from the Chick-fil-A and from El Potosino restaurant that doesn't identify anyone, that by itself would not be able to give you any indication of who those people were. We have the discarded cell phone of the deceased. We have fingerprints from Jeremiah Rodriguez. We have fingerprints from Jalen Bell. That blue iPhone that the prosecutor spoke of. A photograph of Mr. McIntyre and Joanna Reyes, and a letter addressed to Mr. McIntyre. So dirty laundry, toothbrushes. We see very significantly a .380 auto bullet, a live round in the front passenger seat, the seat that they insist Mr. McIntyre was sitting in based upon nothing other than the bare word of Joanna Reyes. But nevertheless, a .380 auto round, a bullet that you know could not have been fired from a 9mm. We have a condom in the back seat.
So what happened?
A wallet, broken sunglasses, a necklace pendant, streamed out in the El Potosino parking lot, a broken SD card. We have these innocent bystanders. And yes, it's normal that people going about their daily lives are going to give detailed accounts of that, but don't accept that as some kind of an apology for the state's shoddy investigation. That's not how you should interpret that. Yes, it's normal that innocent bystanders are going to give conflicting accounts, and so that evidence has to be weighed less than it would if someone was able to give a definitive account. You have no eyewitness identification of Mr. McIntyre. You have no eyewitness identification from any of those people, of any of the participants in the car.
All right, so he's taking the he wasn't there route. Really? What do y'all think about this? I don't know. The first witness we heard, she did say, "Oh, they were brown." They're all brown. No one really did specifically identify him other than, obviously, Miss Reyes, right? So, I don't know, man.
And their accounts differ. We have people saying that all of the members were Hispanic. We have people saying that the man was African American. That doesn't do you a whole lot of good. There are 2 African American people in that car. They conflict about how many shots were fired. How many guns did they see?
That's true.
What exactly was the person doing with the gun? They largely do agree on one important fact, which is that Mark jumped on the hood of that car after he was ejected from it and stomped on the windshield. But let's talk about what you don't have. Each of these things is something that is very important for you to be asking, why don't I have it? And what would it have told me that might have informed my opinion one way or the other? Is that SD card that they found in the parking lot even compatible with a digital camera? Is it compatible with the kind of digital camera they say Mark had? You don't know. We have no idea. What was on the SD card? You don't know. Fingerprints of Tamor McIntyre? You don't have any. None. Any reliable witness who can identify Tamor McIntyre, not even the 2 women going to the massage parlor that day, are able to give a definitive identification of Mr. McIntyre or anybody else that got into that car. An accounting of where the car was in between the time it departed Chick-fil-A and the time it parks at El Potosino. I mean, if we're going to really latch on to this idea that Joanna Reyes says that Tamor was in the front seat and we see somebody getting out of the front seat, aha. Well, okay, we don't know that that's Tamor McIntyre getting out of the front seat, and I don't know what they were doing between the time period that we're in the Chick-fil-A and we parked at the restaurant. They could have stopped to buy cigarettes. They could have stopped and decided to do a Chinese fire drill for some reason. You have no idea, and they don't either. They're asking you to just jump over that. And you're not supposed to be making those kinds of elisions in your logic. You're not supposed to be making those kinds of jumps. That is not common sense. That is not upholding your duty. That is taking their word for it. And that's not what you're allowed to do in a criminal trial. You never get to take their word for it. Their burden of proof prevents it. His presumption of innocence prevents it. You don't have any GPS data from any of these phones. You don't have any cell tower location data. We have warrants showing who called who. Okay, great. Tamor McIntyre and Joanna Reyes were dating. They called each other. That's not a smoking gun of anything. But that cell tower data could have also told you where they were and when they were there, and you don't have it. We don't have a dump of Mark's cell phone. We don't know anything that's on there. We don't have any idea what their communications actually were. We don't have a dump of Joanna Reyes' cell phone. We have no idea where her communications were. She says somebody broke it up in Dallas. We have to take her word for that. We have no corroboration of what Joanna Reyes did at any point in time after we last see her on that El Palcasino video, and we only know it's her on the video because she says it's her. We don't have any examples of Mark's work as a photographer. This claim that it's his passion, this claim that that's his thing, this claim that that was his reason for being in that car, they're asking you to take their word for that. There's no proof of it.
Interesting.
We don't have a single example of this man being a photographer. We don't have a digital camera, the subject of this supposed robbery, or anything connected with the digital camera.
I mean,
we don't have a backpack.
He's kind of cooking. I don't know.
I apologize. When it comes to the gun, we have problems there too. You heard testimony that you could do additional GSR work on the hands of Mark Saldivar to try and determine whether or not there might be additional elements besides lead, barium, and antimony that might give you a key as to what kind of ammunition was used or what gun was fired. That analysis wasn't done. You heard testimony from a firearms expert saying that it couldn't have been the gun. But fundamentally, he admitted at the end of the day, it's a subjective science. It's the human eye that's at work here. And he's basing it off of, mostly, the indentations on that primer. And while he can say that the breech face precludes it from being the same thing, he didn't take the gun apart. So he's speaking about generally what a Smith & Wesson looks like. And he can't speak to the condition of the gun. It's been sitting in evidence for years, 7 years, in 2 different property rooms. And no one came here to talk about whether those rooms are climate controlled, to talk about whether they have an armorer that comes in and cleans the guns. Nothing. And he acknowledged that corrosion can affect how the primer gets indented when it's fired. You have nothing to analyze on those gun magazines, 2 of which are also .380 auto, not associated with that shell casing. And one is a 9mm. We don't have fingerprints on those magazines. We don't have anything to tell us whether they're significant or whether they're not. Except we do know that there were a lot of guns in that car. We know that the perimeter of the crime scene didn't include the access road, which seems to me to be a problem when we don't know how many shots were fired. Because maybe there are more shell casings. There's no way to say one way or the other. This is really important. We have no search of Jeremiah Rodriguez's home. I'm sorry, but their only witness, the accomplice in this case, says that everybody left that parking lot and went to Jeremiah's house. If we're trying to find proof that someone committed a capital murder by robbing somebody else, don't you think we should search the house that they all ran away to afterwards to see if we might find something? Nothing. You didn't hear from Jeremiah Rodriguez. You didn't hear from Jeremiah Rodriguez's family. You heard nothing about that aspect of the case, which would be the best place to find something that might corroborate anything that Joanna Reyes said. They didn't give it to you. This is a homicide investigation. It's a capital murder investigation. A police officer doesn't get a warrant for a critical scene in the case. There's no search of Joanna Reyes' house, her parents' house. She says that she went to Dallas by the Greyhound bus station. You don't have any footage of her leaving. You don't have any records that she ever bought a ticket. Do we even know that she went to Dallas? There's nothing to prove that Joanna ever spoke to Tamor McIntyre again after the 23rd of April, 2017. They have some call logs that show Joanna tried to call him. But that doesn't seem very consistent with what Joanna tries to claim, which is that Tamor was an aggressive and possessive person. Very significantly, you don't have DNA, and you know that they could have tried to get it. They swabbed Mr. McIntyre's cheek, but they decided that it wasn't necessary. They didn't care what the results were. That's inexcusable. One of the witnesses in this case, Jeremiah Rodriguez, lied to the detective for a full interview about there being a 6th person in the car named John. And we don't have DNA to try and determine who's telling the truth and who's not. We're just going to let his gut steer us in whatever direction it goes. Oh, I think you're lying to me. We don't have DNA on the .380 auto bullet. We don't have DNA or fingerprints on the gun magazines. We don't have fingerprints or DNA on the condom. We don't have any testimony from the lead evidence technician, Kim Wong, who did all of the barcoding from the crime scene at the Chick-fil-A to know whether or not the evidence is all accounted for, correctly labeled, and that it was even available to these laboratory analysts to look at. And you know that mistakes were made because they, for years, had a 9mm shell casing labeled as a 40 cal. You don't have any testimony from Jeremiah. You have nothing from Jalen Bell that was said back then or now. Just a complete mystery. 2 weeks of trial. All of those witnesses. This stack of physical evidence here in front of you. What do you have? Tamar McIntyre was in the car at some point. Was he there on that day? Maybe. Maybe not.
Saying they're not there.
When was he last there? They can't tell you. Did he have a gun? They can't tell you. Did he shoot a gun? They can't tell you. Did Mark start this fight? They can't tell you. Was there a fight? They can't tell you. They can't tell you a single thing about what happened inside of that car at all from any of the evidence that's piled in here. Now, their theory, as you know, rises and falls entirely on the testimony of Joanna Reyes.
It's true.
Proving that Tamar McIntyre was in that car is not enough to convict him of anything. Mere presence at the scene of a crime is not enough. The jury instructions tell you that explicitly. As a party, as the primary actor, doesn't matter. Mere presence is not proof beyond a reasonable doubt. That's the law. Joanna Reyes is lying. You know she's lying for several reasons. First, Detective Juarez knows she's lying. Everyone knows she's lying. The state bought and paid for that testimony at an extremely high price. Joanna Reyes was an adult when this crime occurred. She is facing life in prison without the possibility of parole or the death penalty for a capital murder.
That's true.
And rather than facing those consequences, the state offered her a plea to tampering with evidence with deferred adjudication, meaning that she'll never have a felony conviction for this offense.
Crazy.
She'll be eligible to have it non-disclosed, meaning that when she goes out there to apply for a job or get an apartment or do anything, this can be ignored. Won't be on the radar screen of people out there in the free world. And even though it's a 10-year term, the terms of the agreement allow for them to knock off time as things progress, so long as she's truthful. But we all know what that means. There's only one arbiter of whether she's truthful, right? They're not looking at your verdict to decide whether she's truthful. Don't worry, you're not deciding whether Joanna Reyes gets a better outcome or not. The only thing that decides whether she's truthful is what they think. The ones who are calling her to testify. That's not an acceptable way to run a justice system. Compensating people with their freedom to obtain the critical information they need when none of the physical evidence supports it is not a way to run a justice system. Her inconsistencies in her testimony are too many to recall. I don't know if I'm going to be able to list all of them. I know for certain that while Joanna maintained for a long time that this was all Tamar's idea, and that Tamar was the one talking to Mark on the messaging system, and this was what Tamar wanted, and it wasn't me, you heard her on the stand acknowledge that after lying and minimizing that forever and ever and ever, she finally has decided that she can say, all right, well, he contacted me first on Instagram, and he solicited me for nude photographs, and I blocked him. And then I later changed my account, and we got in contact again. And then we talked about this photo shoot, and he wanted it to be in lingerie. This is all about her career as a stripper. There is no evidence that this is actually anything that Mr. McIntyre wanted. There's no evidence that Mr. McIntyre was even aware that she was communicating with him. You have no way of knowing that other than her claim. A claim that she has every incentive in the world to say, irrespective of whether it's true. The idea that the photo shoot was rescheduled as to called off, I think, is an interesting thing. You heard testimony. Mark didn't have any other appointments. And the testimony was that he was basically saying, we're not going to do the photo shoot, but give me a ride to North Star Mall, which is where we said we'd do the photo shoot to begin with. That doesn't make sense. That doesn't make sense. She's hiding something there. I don't know what it is. I can't tell you what it is, but it's not my job to. They have the burden of proof here. And at its core, nothing corroborates her claims. If you want to tell a policeman that despite what it looks like, you are not the getaway driver or the perpetrator or involved in an armed robbery and a death that occurred in the Chick-fil-A parking lot, that it really was all a big misunderstanding, which is what you tried to do desperately for a very long time, you would show the detective your communications with the deceased to clear all of that up. And you would explain how that all develops on. We don't have any of that. She didn't give you that corroboration.
Wow.
And that malarkey about someone broke my phone, they have nothing to back that up either.
He's cooking.
We also know she's full of it because, come on, I thought he was 18. Look at the photographs. No one would mistake that child for an 18-year-old man. He's a 16-year-old boy, and she knew it.
Dang. Yo. He's summarizing this perfectly. Again, y'all mentioned in the comments, I wish we would have heard more of this during the trial, but oh my God. Yo, he's cooking Miss Reyes right now. Jeez.
She was afraid. She had court the next day. There are bailiffs in every courtroom in America. Policemen. Everywhere. If she was afraid that she was going to have something happen to her because of what she saw, ample opportunity existed. She spoke to the detective, in this case, on the telephone. She gave her fingerprints and her ID when she went to go dance up in Dallas. She had her father take her to the bus station, passing up opportunity after opportunity after opportunity. You have to first believe the accomplice before you even go into this question. You don't get there. I don't think anybody can get there. And then, even if you do believe her, you still have to have independent corroboration that connects Tamor not to the scene of the crime, not to the car, but to the commission of the offense. You have nothing. Not a shred of evidence supports that. Zero. Nothing corroborates her story. The justice system in America depends upon the state having to meet an exceedingly high burden. It should be extremely hard to put someone away for capital murder or manslaughter. They haven't given you that. Demand more. Expect more. It is okay to have your doubts, and it is okay to rely on those doubts. It is your duty to expect them to work to dispel them, and they haven't. And lastly, I just want to say, we're counting on you. Tamor needs your help. If y'all don't hold them to their burden, we're going to have a miscarriage of justice today. No one wants that. I count on you to do your duty. I know that you will return a verdict of not guilty as to all of the theories the state has put forward. Thank you. Mr. Goldstein.
Wow. Wow, 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 wow. I'm shocked. I knew they were going to go this route, but John, shout out to John, absolutely demolished Mrs. Reyes' testimony, as he did during court proceedings. And I think that's where they spend a lot of their energy, because as we mentioned here, and as I said before, that was going to be the key to this entire thing, because there were so many inconsistencies from witnesses. Oh yeah, I saw them fighting. Oh, this person was grabbing the gun. Oh, there was a girl in the front and she was brown. They were all brown. I don't know what they were. But Miss Reyes comes up, someone who could be held liable for all of this, someone who's in a very difficult situation right now, someone who was messing with a minor. I don't know. Y'all let me know what you think about this closing arguments. Cooking. Absolutely amazing. Let me know what you think in the comments in the chat. Let's keep it moving. It looks like we're going to have some more conversation from TAY's other attorney. Here we go.
It's going to take me a few minutes. I have to change computers.
And that is Jerry Goldstein, in case y'all were wondering.
May I have a restroom break? Well, if the jury wants me to proceed, I will proceed.
All right, you don't want to continue? All right.
I'll proceed.
All right, thank you.
Wow. Hey, John did his thing, man.
Deliberate. Ladies and gentlemen, you have not been given permission by the court to deliberate. You've heard part of the closing argument, but both parties have not concluded their closing argument. Remember the court's previous instructions, and I'll have you all back here at 11:05. Is that enough time for everyone? All right, everyone, please rise for the jurors.
All right, so the jury's leaving. Y'all know we're on a delay, so we get to skip ahead and see what the Honorable Attorney Jerry Goldstein's talking about up in here. Here we go.
Remaining.
All right, for the jury.
Come on, Jerry. will say I'm shocked they went the was he there route. That's kind of wild to me.
All right, everyone, please be seated.
Thank you, Your Honor. Ladies and gentlemen of the jury, able counsel, Tamar. This is a capital murder case. It's an important case, obviously, to Tamar. But I think we all take it seriously. I've been watching. I can tell you that I'm impressed. I'm going to try and just summarize quickly. Judge Boyd is the judge of the law. She decides the law. You've been watching her rule. I told you we were going to have some disagreements. Objection, instruction, don't disregard. I don't know how y'all keep track of it. We're having trouble keeping track of it. But y'all been paying attention, and I think you've been following those instructions. But y'all, each and every one of y'all, are the judge of the facts, the sole judge of the facts. Each and every one of you, in your own mind, you make these decisions. No one will ever be able to come back and look into your mind and ask you about that. That's important. This is Tamar's case. I told you I was going to summarize, so let me just tell you that there were a lot of inconsistencies. I told you a lot of this was going to be kind of boring. It's like watching paper. I mean, it's, you sit there and watch over and over again. And I said, that's because that's their job. They've got to do it. They're able counsel. I respect them. They're trying. And they've got to put that before them. But there are some things in dispute. One of the things I talked to you about was inconsistency. There were a lot of inconsistencies here. For example, one of the witnesses, I think her name was Ashley Buentello. She said there was a female driver. Another said they saw only females in the car, and that was Eliza Adams. Another said there were 2 males in the front seat. That was Anna Delgado. Some said there was 1 shot. Some said there were 2 shots. There were others that said there were 3 shots. Joanna Reyes, who we're going to be talking about her at the end. You heard able co-counsel John Hunter talk about Miss Reyes. She said she couldn't remember. She was in the car. She couldn't remember how many shots. We're going to talk about, you've already heard some things about the police investigation. I kind of like Sergeant Detective Raul Juarez. He's an able and he's professional. But let me just tell you, despite all the swabs they took, you saw the officers swabbing each parts of the car, all the evidence. It's interesting. They never took they took our client's DNA, they never compared any of that. There was no effort to do that. Why? The 9mm weapon, the one seized from Jalen Bell, it was never even compared to the spent cartridge. It sat there for 7 years in Fort Worth, then it was brought to San Antonio. And that wasn't done until we asked for it. 7 years later, they had never done that. I don't think guilty people would be asking for that sort of thing. The spent round, the 1 spent round found, where was the lead crime scene investigator, the CSI? Remember the woman, the only way I remember is that they had a lot of pictures of her high heels. There's nothing wrong with high heels. My wife of 55 years wears them all the time. But where was she? She's the one that picked up all that evidence. She's the one that bagged it all, remember? Where is she? That nice homeless woman, she managed to get here. They have the burden of producing evidence. Where is the officer that made that you saw the report? It's in the evidence. The report where he says it's what did he say it was? A 40 caliber, the 9mm cartridge? Now that was a mistake. Is that a giant mistake? Is that a reasonable doubt? I don't know if that's a reasonable doubt. But we're talking about cumulative. This is not our best efforts. There were no fingerprints obtained from the vehicle of Tamar. Didn't they compare any prints? There weren't any done. There were no fingerprints of the magazine. Remember, there were 3 magazines found, only one of them a 9mm that he just showed you. It fit perfectly in the weapon seized from Jalen when he was arrested 5 days later. There was no search of any residence. Why is that? I mean, you see it all the time whatever you watch on TV, when they're trying to find people, they always go to their residence. They seize their residence, look through their electronic media. There was no search of Joanna Reyes' residence. There was no search of Jalen Bell's residence. There was no search of Mark Saldivar's residence. There was no search of Jeremiah's residence. Remember Jeremiah Rodriguez? That's where they went right after this happened. Why wouldn't you want to search there? Why not? Well, our able detective said that when he need to, he had made it. He doesn't get to make. The law is very clear in this state. No witness, no matter how much we like them and no matter how professional they are, no witness gets to make your decision for you. No witness gets to tell you who's guilty and who's not. Not in this country. Y'all get to decide.
Fair.
He decided that early on. That's why he didn't do it. He told you. I didn't think I needed to. Jalen, let's get to the facts of this case. Do all those things amount to a reasonable doubt? Did any one of them amount to a reasonable doubt? Do they cumulatively, all of them together, amount to a reasonable doubt? I don't know. That's your decision, not mine. But it's certainly in the best performance by our San Antonio police force. Jalen Bell, he had, there was only one 9mm retrieved in this case, and it was seized from him. And remember the testimony by Joanna Reyes? Yeah, he had a gun that day. He always had a 9mm. This guy, he always was packing. And it was a 9mm that he packed. Think about that. There was one spent cartridge found that they didn't even compare until we asked for it 7 years later. And one weapon, 9mm, one cartridge, 9mm. Was it but Jalen Bell seemed to always have a 9mm with him. That was how he ran. Jalen Bell's are the only fingerprints they took, and they were on Mark Saldivar's telephone. Jalen Bell. Remember, that guy's a big boy. 6'4", 240 pounds. Mm-hmm. Tamar, a little slight. 15 when Joanna Reyes met him. 16 when this happened. Jalen Bell's the one that rummaged through the backpack. He's the one that the testimony has rummaged through the wallet. What about him? Why not search his house? Where is he? We don't have any obligation to, you heard the charge, I know it's long, but take a look at it. It tells you that we don't have any obligation to bring in any evidence. Not to call any witnesses. It's the prosecution's burden, a heavy burden. They have to prove beyond a reasonable doubt every element of the offense. Why didn't they bring Jalen Bell?
Time.
I thought I was going to get a warning.
I did.
Okay.
Thank you. All right, State, are you prepared to proceed? You have remaining 16 minutes and 47 seconds.
May I have, I prepared this last night. Can I just have a few minutes more?
Now, both sides agreed to 30 minutes. That's what both sides are receiving.
I'm going to beg the court. Can I have 2 minutes?
No.
Dang, ow, he fumbled. What? Oh, I've never seen this happen before. This is awkward. Dang, he shouldn't have been talking about his wife's high heels. Oh, that's crazy. He ran out of time. Dang. I've never seen this happen before. Come on, Pops.
Dang. State, are you ready to proceed?
Yes, Your Honor.
That's embarrassing.
Just our second judge just got to set up the text.
That's so embarrassing. Oh my goodness. She said time. He said, huh? But you know what? Initially, I was going to say they should have let him go first because he was going to be more long-winded. I'm glad they didn't. And they know what they're doing, obviously, because John needed to get those points across that he got across. And then we had the honorable attorney Jerry Goldstein just adding a little bit of icing on the cake. What do y'all think about that? Jesus. Let me know what you think in the comments in the chat. Yo, that's tough. 30 minutes total. All right. So I think if I were to guesstimate, the prosecution's going to have about 15 minutes each because that first prosecutor, she was in and out in 15 minutes, if not less than that. So now we're going to get into, again, rebuttal from the prosecution. Here we go. Yo, that was crazy. I've never seen anything like that.
Ladies and gentlemen, I'll be the last one speaking to you. I know it's been a long 2 weeks, so I'm going to try to be as brief as possible. As you notice, the judge is going to hold me to a 16-minute time interval. So after I speak with you, you're going to have the opportunity to go to the back. The charge that the judge read to you, you're going to get that, a copy of that. You're going to be able to review that back there, okay? So what I'm going to do is jump right in and about the capital murder here. The state has proven every single element of capital murder. If you look at this on April 23rd, most of these are not in contention here. April 23rd, 2017, Bexar County, Texas. The death of Mark Anthony Salvador was by a deadly weapon, by a firearm, by a shooting. And the only thing in contention that defense is arguing is Tamor McIntyre was not the one that did this while he was attempting to rob. I think the evidence overwhelmingly, if not beyond a reasonable doubt, beyond almost all doubt, that we have the correct individual. I'm going to talk about Joanne Reyes briefly right now and then go over evidence with you that came on in this case. Right here, I'm going to read it to you. Joanna Reyes, accomplice. She is an accomplice to this. She did plead to tampering with evidence of that car. She fessed up, took responsibility for her part. She did not shoot Mark Salvador. That man right there did. That's what we're trying to do, is make somebody that killed someone take responsibility. Joanna took responsibility. You look at all the evidence. Joanna did one thing. She was driving that car. You saw when she got out of that car. She's freaking out. You heard testimony from Jasmine Cruz saying she looked freaked out. If you watch that video, what are those two other individuals doing? Jalen Bell, 6'4", 200-something pounds, and the slight individual, Mr. Tamor McIntyre, walking around like it's another day. A day in the life of Tamor McIntyre. A day in the life. That's what Joanna gave you with her testimony. That's what she gave you. A taste of the life of Tamor McIntyre. A person that shot down another individual for the sole purpose of taking a camera and a backpack and $10. That's a day in the life of Tamor McIntyre. Just one day. She was an accomplice, but she took her responsibility. Defense counsel's correct. She's getting deferred. She's been on bond for over 7.5 years. Has abided by that. Has not broken the law, has not broken bond. She came in here and testified. And you know what people do, or what they're labeled as when they testify? Snitches.
Your Honor, may we approach?
I mean, she kind of was a snitch. She was a snitch. I mean, let's be real, prosecutor. She was snitching. She's telling what happened, pointing fingers so she can get a lesser sentence. They teach this in snitching 101. I mean, come on now. She was there. She was involved. Maybe she didn't want anybody killed. That's fine. And I don't have a problem with snitching. Just be an honest snitch. All right, come on, man. Dang, here we go. I'm snitching. I'm just going to be like, sorry, guys.
Ladies and gentlemen, I'll go into Joanna Reyes. She is an accomplice, but she took her responsibility, has taken her responsibility. Her testimony needs to be corroborated by other evidence, tending to connect the defendant with the offense. Tending. Not beyond a reasonable doubt, just connecting him. Tending to connect him. Okay? Keep that in mind. But then, after you find that evidence, that corroborating evidence, you add that with all the other evidence that came in this case, including her testimony, including what she said, and everybody else had all the evidence, and then you must believe beyond a reasonable doubt that the defendant is guilty of the offense charged against them. The corroborated evidence that corroborated her, and then also all the evidence, including her testimony, equals a guilty in this case. Let's go over that. This is the video. I want you to watch this video if you need to over and over, unless you've seen it enough already. The fact is, if you watch that video, one, Mark Salvador stomping on that windshield. No doubt that he stomped on the windshield at some point. But you watch that car and it lurches forward, what does he do? He falls down on his hands and knees. He slides off that vehicle as it goes back. Then you see the white shirt pop out. Boom. If you listen to the ME's testimony, that individual was shot in the shoulder. Mark was shot in the shoulder. It was from left to right, downward, from front to back. He wasn't standing up stomping on a windshield. He was on his hands and knees, being shot by Tamor McIntyre to his left. It went across his body and exited out his lower part of his back. Look at the evidence. He was not stomping on a windshield when he was shot. You see it from that video. Chick-fil-A video. The corroborating evidence in this particular set is the fingerprints of his accomplice, Jalen Bell, that has been testified to thoroughly. Jalen Bell is best friends with Tamor McIntyre. They still had contact after this.
Mm-hmm.
They still had contact, much contact.
I'm snitching on everybody.
Months ago. In fact, if you listen to State Exhibit number 118, you hear Tamor McIntyre say, I gave pimps money. Gave him money, so why did he give him money? But Joanna Reyes is getting bought off. Remember that.
Well,
fingerprints of the accomplice Jalen Bell, best friends. The jail calls tell them about that best friendship and also money being transferred to Jalen Bell from Tamor McIntyre. They arrived together in town in San Antonio, and then they left together and escaped off, one to Dallas. Jalen Bell gets caught there. But if you listen to the testimony of the officer there was another individual with him. Who was that individual? Where did that individual go after his buddy got caught? He ran off to New Jersey.
It's a great point, Steve.
Connection to what? That letter that was found in the car. That's also corroborating evidence that he was there at the crime scene and committed this crime. All together. Also, testimony in here, you got that shell casing that was tested against the gun. It did not come back to that gun. You heard about the one shot. Several witnesses testified to that. You got shows that the front seat passenger in the white shirt, watch the video, it's a white shirt. Watch the El Paltacino video, it's a white shirt. El Paltacino video, as they pull up, or when they have pulled up already. That's Tamor McIntyre walking around a car. That is Tamor McIntyre in that white shirt that got out of that front seat passenger, and that's the individual that shot Mark Salvador. If you look at the timestamps on these videos, also at the beginning of each of the videos, you'll notice that the times 5:19 was in the Chick-fil-A parking lot. When the initial video of El Paltacino, it's registering at 5:20. Maybe a minute from one location to the other, if not seconds. So that Chinese fire drill that defense counsel was mentioning, probably a pretty fast one, I guess. El Paltacino, the black key is there. This shows the 4 individuals in that vehicle. You have been told who those are. The white shirt of Tamor. You watch that video image, and that's Tamor's physical body. He is a 16 and a half, almost 17-year-old individual, slight build. He's growing up. He's growing into Tamor McIntyre. The wallet is found of Mars, establishes robbery at this location. You watch that video, you watch Jalen Bell, 6'4" of him, 240 pounds of him, putting on a backpack. You see it as he goes out and he's walking with Tamor McIntyre. You see him take the backpack off and then rearrange, and they walk off into the night, or the day rather. More corroborating evidence, a lot of corroborating evidence in that black Kia. How many of you, everybody in this room, where's your cell phone right now? You know exactly where your cell phone is. Tamor's was in the glove compartment of the black Kia that was in the murder investigation. That's where his cell phone was.
Whose Kia was it, though? We didn't forget
You know
that.
where your cell phone, everybody knows where your cell phone is. Tamor McIntyre left it in a car because he was running off into the day to get away from that vehicle from a murder. You also heard my co-counsel, Ms. Galloway, talk about the phone records. That's in evidence. Tamor's phone records compared to Joanna's phone records. There's intermediate phone numbers mismatched several times. Jeremiah's fingerprints are found in that car. Sergeant Juarez established Jeremiah was in that car through his investigation. He was interviewed by Sergeant Juarez. His rendition, his interview is consistent with all the other evidence that was collected. Clothes of Tamor, Jalen, and Joanna were found in that car. The slides, the jerseys all match up with Tamor McIntyre being in that vehicle. Letter belonging to Tamor McIntyre is in that vehicle. Also, the photo in the center console of Tamor and Joanna. If you look at this, that photo on the left-hand side is that photograph that's laying in the console in the middle. Shows her in a jersey of that Chicago, some type of football jersey with Tamor. What you can see is white high tops, Nike. The wallet to your right is Mark Salvador's, testified by Miss Salvador, his mother. That's evidence of a robbery. That's not the scene of where it happened. If it happened at Chick-fil-A or at that intersection, it was ongoing the whole time. If somebody's robbing you, they're taking it, and you're trying to stop them from taking some of your objects, you can try to stop them. He tried. Corroborating evidence, all four of these witnesses testified a young black male in that front seat with a gun. Ernest Reyes testifies that Mark screamed, "Help, help, give me my things, give me my things." Evidence of a robbery. Witnesses, Ana Delgado, Gabriel Baez, Jasmine Cruz, which we've already spoken about, describes that scene when she was there. Lucy Salvador, the mother of Mark, establishes Mark was excited about a photo shoot.
5 minutes.
911 callers, you've heard from all of them. Little inconsistencies, I agree. Defense counsel is very able to determine, some Hispanic, a white person or something like that. But, the fact is, if you look at the consistent things, front seat shooter, a gun, a black car, and guy on the hood. Consistent with everybody else's testimony. That's one word you're going to hear over and over is consistent, consistent, consistent. Tamor runs off to New Jersey. He's found up there, and then he's brought back to Tarrant County. Then he's brought back to Bexar County to face these charges. Tending to connect the defendant with the offense, everything that I just went over, but reiterated. Fingerprints of the accomplice, Jalen Bell. Jail calls established McIntyre and Bell's friendship. Video image of El Paso matches Tamor's physical body. The blue iPhone belonging to Tamor McIntyre, that phone. Tamor's phone records are Joanna's phone records. Testimony of Mark's phone number on Joanna's phone records. Jeremiah interview consistent with all this evidence. Clothes of Tamor and Jalen and Joanna in that car. Photo in the center console of Joanna and Tamor. And then the letter belonging to Tamor. This is all corroborating evidence that you can use in your determination of an accomplice, witness, testimony, and the truth of that. Because the fact is, there's that letter addressed to Tamor. The same place where his phone is found in that vehicle. Remember, corroborating evidence just needs to tend to connect and the defendant to this offense. 10. Doesn't have to be beyond a reasonable doubt. But then you add all this evidence together, all of it together, and you get a view of a credible evidence together, and you get consistent evidence confirmed by overlapping evidence, video, testimony, and all other collected evidence equals beyond a reasonable doubt of guilty. Easily. Briefly, if capital murder, that's what we're asking for, the guilty. And just to briefly, since it was brought up, if this is self-defense, what are we looking at then? What type of society? If robbing a victim and then say, I'm asking you to enforce the law here, because if you're robbing somebody,
why do you close like
and
that?
you take something from somebody, and then you argue that the defendant or the victim doesn't have a right to get it back. Not you. The defendant provoked the victim by taking his things, his passion.
2 minutes.
Mark Anthony Salvador died that day. Justice for Mark Anthony Salvador. He had a passion of photography. His mother testified to that. That's evidence. He had that camera that you see in this photo that was never found, my dad. I agree with counsel. Never found. Why? Because of that man and his buddy. Make him take responsibility. You go to the page and this charge and go to capital murder, and then you flip to the back to the verdict form and say guilty of capital murder, because we have proven every single element beyond a reasonable doubt, especially that this individual, Mark Anthony Salvador, deserves justice. After so long, so many years later, he deserves justice. And just because it's old doesn't mean that it's bad evidence. But he deserves it. His family deserves it. Heck, we all deserve that. We don't want a society like this.
Objection and proper argument.
We want law enforcement, and that's what I'm asking for. Hold Tamar McIntyre, TAY-47, accountable, and come back with a verdict of guilty on capital murder. Thank you, ladies and gentlemen.
All right. I mean, the landing was rough, but the takeoff and the ride, it was pretty smooth. It's pretty smooth. Let me know what y'all think about this in the comments in the chat. That might be it. What's the verdict going to be? That's what I want to hear from y'all. Guilty, not guilty. Will we get it today? We'll have to wait and see. Oh my goodness. I got to read a super chat real quick from my guy, Les Cleaver in the building. Shout out to Les Cleaver. He says, back to work for me. Please be safe and be loved. I'll catch up after work. This is the best channel ever. Oh, well, I mean, hey, Les said it. Shout out to my guy, Les. Love my CEB family. And we love you too, man. Enjoy the rest of your day, Les. All right. What do y'all think? I'm going to read the results of the poll here shortly, but let's see what Judge Boyd has to say in closing before they start to deliberate.
All right, ladies and gentlemen, you've heard all the evidence that you're going to hear. Both parties have concluded their closing arguments. I'm going to send you to the back with the deputy, but before I do that, if I can have defense and state here, please.
All right, Judge Boyd has some final words. Are we going to hear anything else from her? Or is that it? That might be it, y'all.
Oh, don't forget your water.
Okay, looks like that might be it, y'all. We made it. 9 days, and that was it. 9 days it took for this. Oh, we've got a not guilty in here. Okay, Anna. Anna, let me know in the chat why you say not guilty. I see everybody saying guilty. Y'all can let me know your thoughts too. But I want to hear from some not guilty folk, because if you look at the poll right now, and over 200 of y'all have voted, 68% of you say guilty. 14% say not guilty. All right, Laquan says not guilty as well. Let me know why. We've got 9% of you say guilty on only one count. That would be interesting. And then 9% of you say a hung jury. I want to know what y'all think about this. Anna says reasonable doubt. I mean, it's fair. No one other than the stripper who's looking at life and possibly the death penalty were able to identify Tay. We didn't see him in the video. We weren't able to see the communications back and forth between him and Miss Reyes. Not enough physical evidence, says Drewski. Cole Hart says they can't use their feelings, and that's what the prosecutors are trying to get them to move off of. Yeah. Is this the society we want? Come on. What does the evidence show? That's what we want to talk about. I don't care about what society we want. What's the law? What does the evidence show? Did you do your job? That's the question. Not guilty. I see another not guilty. Amy says, I think the defense did a great job of creating reasonable doubt. So, not guilty? Not enough evidence to prove that he did it. Based on the evidence, they proved their case, says Mr. Brown. Did they prove their case? This is a tough one for me, but Mr. Brown, even with that, says not guilty. Okay, so there's a lot of not guilties in here. Yamula says not guilty. Cold Heart, not guilty. Not guilty from Drewski. Not guilty from Laquan. I think Amy's leaning not guilty. Not guilty. Mo Max says, what more evidence do y'all need? I wish we could have seen the video of what went down. I mean, can you clearly identify TAY from those videos? I don't know. Not guilty of capital murder. Indecisive. The journey of peace and mind. I might be with you on that. Amy, I'm not responding. Oh man. Yep, Amy, hard times out here. Hard times. Mo Mac is convinced that this is a guilty. Four-door Oldsmobile Cutlass says not guilty. That's a nice car. What year? What year is that? 87? What year is that? What year is that four-door? Here's the thing. The defense made it is an 87. Oh, yes, sir. I see you over there. That's a nice car. The thing about that is there was a lot of the story that was left untold by the prosecution. What was the communications before this all went down? What were they talking about? Is there any indication that they planned to actually rob him? Where's Kim Wong? Why did she flee the country? And why weren't any charges filed against Miss Reyes until they needed her to testify? Oh, just put 6.0. Oh my God. Okay. Don't get me into talking about cars, four-door Oldsmobile Cutlass. Don't distract me. Lack of solid evidence, lack of police work. Can't find someone guilty on what a girl stripping and running place says. Oh my gosh. Especially not facing capital murder. Don't forget the death penalty. I can't wait until the Karen Reed trial. Yep, should be coming up soon. Why did she leave the whole force? She's gone. Kim Wong was out of there, right? Where is she? Where's Kim Wong? Been there before, not guilty. Y'all must don't watch trials. As she pointed at him out and said he did, he's getting guilty. Yeah, we don't really, Kaylon, we don't really watch trials like that. Amy says reasonable doubt is the legal standard of proof required to violate a criminal conviction in most adversarial legal systems. It is a higher standard of proof that it is the highest standard of proof than the standard of balance of probabilities commonly used in civil cases. The prosecution bears the burden of presenting compelling evidence that establishes guilt beyond a reasonable doubt. It took the spaces out. I don't think he meant to kill him. Mo Mac, let me ask you this, and let me ask all of my guilty folks in here. Do you know beyond a reasonable doubt that TAY was the one that pulled the trigger? Let's say, for the sake of argument, TAY he planned everything, right? So yeah, we gonna meet him. Bring your girl. You got a girl? Bring your girl. All right, cool. The girl shows up. We're gonna film the video. They get in the car. They're scuffling. They're fighting. They're moving around. He's got the gun. He's like, give me your camera. I ain't giving you my camera. We get all the way to this point. They're moving back and forth in the car. The gun's out. Mark jumps out the car. He gets on the windshield, starts stomping. What happens there? Do we know? Do we know for sure that TAY was the one who pulled that trigger and fired the gun that killed Mark Anthony Saldivar? Mo Mac, you say you believe so, but do you know beyond a reasonable doubt? The state did not prove that to me. I don't know who pulled the trigger. I don't know what happened. I just know the stripper was up there. She was crying. She said homeboy was in the back seat. There was other people in the car. No GSR. A bullet was fired and somebody died. I don't know beyond a reasonable doubt that this is the man that pulled the trigger. And Mo Mack, I think if you're being honest, I don't think you do either. Because all we have to go on, which is the defense's point, all we have to go on is the testimony of a stripper who's facing life in prison. All we have to go on is the testimony of a former stripper who was messing with the 15-year-old and could be facing the death penalty. I do not know beyond a reasonable doubt that TAY was the one who pulled the trigger here. And I don't see how anybody else could say that. And that's really what we're talking about. The state did not do their job in showing that. I don't know that he's the one that pulled the trigger. Mr. Brown's in the building with a 2-bomb up in here. Shout out to Mr. Brown. He says, I'm just showing love. Thank you, Mr. Brown. Thank you so much. Now, the eyewitness testimonies for this were absolute garbage. And I think we were clowning them the entire trial. It's like, you don't know what you saw. Why are you here? Why are you here? You saw some brown people in the car moving around. The guy that ended up dying jumped out of the car and stomped the windshield, or he was on all fours on the hood, like some of them said, and now he's dead. That's all we know. We do not know beyond a reasonable doubt who pulled the trigger. And if I'm a juror and I'm in there with the other jurors deliberating, I'm gonna look at each one of them. Said, do you know that he's the one who pulled the trigger? Oh, you do? How? How do you know? I don't know that. Okay, you say, did the state prove that? Did they show you what evidence did they show you that this man was the one who pulled the trigger? Is he a POS? Is he a POS? Absolutely. Was he going down the wrong path? Sure. Was he in a bad situation? Yes. Should he have never been there? 100. Do you think he was going to rob Mark Anthony Saldivar? Yes, no doubt. Did he pull the trigger? I don't know. Mo Mack said, I think he did. Mo Mack said, I believe he did. But we don't know. The state was weak. I've seen them do better. The state dropped the ball. They don't care about justice for the victim. They didn't put enough work in to prove that it was him or someone else in the car. Even if he's found guilty, is that justice? Justice would be solid, concrete evidence to prove. So if he's found guilty without evidence, who is that justice really for? This case reminds me slightly of Justin Johnson. He said it wasn't him. The other guy knows who was with him when Dolph was, The stripper knows who shot that guy. She was there, in my opinion. That's a big factor. So are we calling the girl a liar? Are we calling the girl a liar? I'm not calling her a liar. I'm not saying she's the one that lied, Mo. I think she's saying, like you said earlier, she's saying what she believes. I think she believes that TAY was the one who shot him. But what she believes doesn't really matter, does it? What she believes or what she thinks or what she says she saw doesn't matter. It's what the state can prove. The burden of proof is on the state. And if for you, if her testimony in light of everything that was going on is enough for you as a juror, then that's fine. That's for you to decide. But if you ask me, did the state, who has the burden of proof, prove beyond a reasonable doubt, her testimony included, that this man was the one who pulled the trigger, I'm saying no. So I won't call her a liar. I'm just saying that's what she says she believes. And Miss DB said it. I believe she's trying to stay out of jail. She don't want to face the death penalty. I said, just come on up here. What'd you see? Did you see Tay pull the trigger? We heard her. We heard what she told the investigator. It was a different story. She's a moron. She's a moon-faced liar, y'all said. When the other person fleeing the country and no one can say for sure he pulled the trigger then. Most states just want someone locked up to suffice the family who lost a loved one, etc. Most times people don't do enough investigation in some situations. She was there. She knows. She is lying about something to downplay her role for sure. He's not an altar boy. He's a robber and a person who unalives people. She may have tried to cover up for her man. Mo Mac, listen, Mo, I'm just a regular guy. I'm not an expert in this. Together, we viewed hundreds of hours of trial footage. So we get and understand how the system works, right? But looking at this as a juror, as someone who has to sit there and ask myself, did the state prove beyond a reasonable doubt that this man committed capital murder? I would have to say no. Yes, there can be a hung jury for sure. I'd have to say no, they didn't prove that. By snitching on him. Yeah, and I mean, I don't think she did it, so I hope she did enough to not to stay in jail for whatever it is, evidence tampering. Right? She's trying to save herself. Yeah. Let's see. I don't know if the jury is officially deliberating. Yep, the jury has been deliberating for 1 hour. So what do we have? 4 hours left in the day. What do y'all think? Do y'all think there's going to be a verdict today? Oh, and shout out to Amy. Yeah, my bad, Amy. Amy sent me some cake. Oh, Lord. She said it's time to eat. I'm ready for some cake for sure. Thank you, Amy. I appreciate you. Shout out to Amy with the super sticker. I know. Michi says no verdict today. I'm with you, Michi. I don't think there's going to be a verdict today. If there is a verdict today, I think it'll be not guilty. I'm going to be honest with y'all. Because the more I thought it through, the more I had conversations with you guys. It's like the state they have to prove that he was the one that did this. And they didn't even get close to proving that Tay was the one who did it. Did they prove he had a gun? Yeah. Did they prove he was in the car trying to rob them? Maybe. Might be one if they don't want to come back Monday. If there's a verdict today, I would put money on not guilty. I think there will be one today, but if not, they're coming back tomorrow morning. If they come back on Monday, then I'll kind of be like, dang, I think TAY, I think he might be done on this one. Where are the other guys that were in the car? Where are they? It's a great question, Mo. All right, y'all. Amazing trial. Thank y'all for being here with us, for giving some great insight, some great feedback. Let's go ahead and end this poll so I can get the official results. And let me actually, I gotta look at my phone to see. So the official results of the poll, where I asked y'all, what will the verdict be? 63% of you said guilty. 18% of you said not guilty. 9% of you said a hung jury or guilty on one count. Thank you to everybody that voted. We are going to be dropping content throughout the rest of the afternoon, throughout this weekend. So if you haven't yet subscribed, hit the notification bell so you don't miss any time that we drop a new video, and go live as well, because I might go live this evening or later this afternoon if they have a verdict. We'll see. Either way, I appreciate y'all. Hope you have a great rest of your afternoon. Thank you to everybody who contributed to the show. Thank you to everyone that sent in super chats and liked the video. Y'all know what to do as always. Now that it's the weekend, keep growing, keep pushing, keep it classy. We gone. Y'all take care. Peace.